argument which we began yesterday, and it is you, Mr. Masuku, who is up now. You may commence.
Thank you, President, and members of the panel. Mr. Smelan and myself have split our arguments. I will deal only with what we will call charge one for lack of better terminology. But because we have prosecutors on the other side, perhaps we should call it charge one, which relates to the dual status, the allegation that Judge Makhubele held a dual status. But before, and then Mr. Smelane will deal with the rest, charge two. What I thought I would do, listening yesterday to my colleagues' submissions and reading their heads of arguments, and also just listening to the questions, was to start off by just looking at why we're here, which is a question one of our colleagues raised at the beginning of their submissions. Judges, like every other persons who hold public office and wield extensive public power, at some point must be held to account for the power that they hold, for the positions that they hold. And this tribunal, being a subset of the JSC, is in fact a process in the accountability process that, or accountability requirement that judges ought to be exposed to. So judges are aware that they are held in high regard, high esteem, and that their private or public conduct could bring the judiciary into disrepute. But that where that happens, they ought to be held to account. Now, there is a balancing, the accountability requirement must have a balancing responsibility. In other words, this tribunal here must balance competing constitutional interests. On the one hand, to hold Justice Makhubele to account, on the other, to also be fair to her, because the principle of fairness is a very central principle to any adjudicative process of this nature. There is a heightened requirement of fairness where you are investigating the conduct of a judge, where the possibility is that the judge may have to return to judicial office. And if the tribunal has not held the balance of fairness properly, it may well be that even if a judge is found not guilty, that because of what has been said during the tribunal, of the words that have carelessly been thrown around, that judge does not have the dignity that a judge ought to have in order to perform the functions that they need to perform. Yesterday we listened, and we read this with horror. Judge Makhubele is accused of many things, and I will read just one aspect that is a deeply concerning aspect. That even when you hold her not guilty, even if you come to the conclusion that she's not guilty, these words that have been spoken very confidently by the prosecutor, by the evidence leader, will remain engraved on paper and will remain engraved in the heart of Justice Makhubele as well. So there are certain words, certain terms that ought to be used with circumspect, because without any evidence, they will have a lasting effect on the judge's character and undermine the judicial office very seriously. There were many, but we came up with the conclusions that are drawn, or that the evidence leaders seek to have this tribunal draw from the evidence that has been presented. In paragraph 314 of their submissions, when they have spoken about what the difficulties they have, this is what they seek the tribunal to draw inference or to conclude: that Justice Makhubele acted intentionally to further an illicit, unknown purpose. Let me stop there. Is there evidence that Justice Makhubele intentionally or unintentionally furthered an illicit purpose? Was there evidence of that nature that was submitted? We submit there was none. But that submission sits in the submissions of the evidence leaders. There's a submission, paragraph 314. I beg your pardon. It's not the submissions of the evidence leaders. I apologize. It's the submissions of the complainants. It is the complainants that seek. There are a number of them. The complainants have not submitted a single shred of evidence that support that kind of conclusion, that there was an intention by Ms. Makhubele to further an illicit, but they also say unknown purpose, which is an oxymoron, because how can an illicit purpose be unknown? I mean, I think that's just also an attempt to simply throw mud at Justice Makhubele. Something must stick. So if you use strong words like illicit purpose, unknown purpose, something must stick. And then they say in paragraph 314, Justice Makhubele acted in a reckless way with utter disregard for the PFMA, the law, and her ethical obligations to PRASA, while pridefully refusing to be questioned or admit her error. Just words like pridefully, you're talking about somebody who is a judge to whom is extended a presumption of integrity and dignity. It doesn't matter how much you despise Justice Makhubele as a judge. Our responsibility sitting here is to ensure that we conduct proceedings that advance what the Constitution says in section 165(4), that assist and protect the courts to ensure independence, impartiality, dignity, accessibility, and effectiveness of the court. If I sat here yesterday and I listened to the evidence leader, Mr. Pavi saying that Ms. Makhubele has committed criminal acts, we have a judge who has been accused of a crime. But we ask ourselves, where do criminal acts, who investigate crimes? Who must investigate a crime? What is the crime that, I know they say it's the PFMA criminal crimes, we'll deal with that. But it's words like those that devalue and diminish the process that is meant to engender public confidence in our judges, irrespective of what you think of them. And I'm not saying that you have to be memby-pemby about a judge who has committed errors. You've got to be forthright about it, but sometimes you've got to be circumspect. what words you use in order to describe the conduct that you're dealing with. Once you introduce the word of crime, and you're saying that a judge has committed crime, you're asking this tribunal to investigate a crime. That's not what this tribunal was established for. But this was for the show. This was for the big show. Judge Makhubele, the so-called state capture judge, is accused of crimes, is accused of pursuing illicit purposes, and it's somewhere, I can't quite remember where that is, but I will find it, where Judge Makhubele is also accused of, but it is definitely by the complainants, is accused of assisting in corruption. What evidence is there that she assisted in corruption? This tribunal has to be very, very sensitive to how a colleague or a judge who must go and serve the public in the capacity of a judge, how that judge is treated. Judge Makhubele has not been treated fairly. I must say that very boldly. She has not been treated fairly. One of the things she has not been treated fairly on is the fact that she has had to beg for the government to fund her legal representation. I'm the second or third legal representative that she has asked for. She has had to change legal representation in midstream because the state, which has a duty under Section 165 to assist and protect, if you look at 165.4, it is a constitutional obligation that a judge who is facing misconduct complaints against them, which has the potential to undermine judicial independence, must be assisted by the state, so that there is no question that the state intends to act fairly against that judge, so that ultimately what is protected there is the independence, the impartiality, the accessibility and effectiveness of the courts. Judge Makhubele has not been treated fairly by the state, which has an obligation to ensure that when she is facing this kind of tribunal, she's represented consistently by counsel, by legal representative, so that she presents the best case that can protect the office that she holds. In the middle of nowhere, she in fact had to start representing herself at some point. That can't give a judge a dignity at all. No judge would want to be treated like that. And we urge this tribunal to just have that context in mind as they evaluate even what they call the unsatisfactory presentation of the evidence. Because here was a judge being a witness and a legal representative at the same time. And we suggest that the purpose of this tribunal is to ensure that, is to meet those requirements of ensuring that the office of the judge, whatever position one takes, retains these attributes of dignity, effectiveness, impartiality, independence. Those are non-negotiable attributes of a judge and the court. And a tribunal ought to be sensitive to how they conduct a fair hearing. In fact, a fair hearing is a non-negotiable attribute of any processes I've already mentioned. That is not to say that we don't regard this tribunal as having acted with sensitivity and I'm not casting aspersions at all to the tribunal members. I'm suggesting that there was a very gross unfairness in the sense that Justice Makhubele did not have a legal representation. She had to constantly raise the issue of legal representation and the fact that no counsel or some counsel who has been appointed has not been paid and there's complaints about payment and all that. That cannot be a fair way of conducting proceedings against judges. Yes, so I'm going to now deal with the issue that relates to the terms of reference 1. I'm avoiding to call it a charge because this is not a criminal process. But let me predicate the submission by affirming and supporting what Judge Mochidi said about these this tribunal process. In this process is an inquisitorial process. No one has an honest to prove anything. I mean, I know that there was a spirited attempt by the evidence leaders who ideally should hold an impartial position. An impartial position says that the evidence they lead must both be positive and negative. So they should have found evidence for Ms. Makhubele, Justice Makhubele. They should have found evidence against her. That is the role of the evidence leader. That's why they're called evidence leaders and not prosecutors. You will not find a single piece of evidence that they raised which was in favor of her. In fact, what I was listening to Advocate Pava yesterday make the submission that, which was also backed up by the Mr. Bishop for the complainants, which was that you've got to find that Justice Makhubele lied because she didn't put a version to Judge President Mlambo, senior head of arguments. I mean, in fairness, when you are an evidence leader and a version has not been put to a witness, what is your responsibility there? What is your responsibility? If there was a version that had not been put, and that version was necessary for the tribunal to reach a fair and a balanced conclusion of this matter, what was the evidence leaders, what was the role of the evidence leaders in those circumstances? Because this is an inquisitorial process, the rules of engagement are really more relaxed than an adversarial system. So to try and draw from an adversarial system or principles from an adversarial system and to try and impugn the integrity of a judge simply because she did not place, she did not ask a colleague a certain version when they are evidence leaders, just misconceives the role that the process is all about. If there was evidence that was supportive of Ms. Makhubele, this was not a criminal trial. If there was evidence supportive of Justice Makhubele, that should have been presented. So if it was important that Justice Mlambo is called back to come and explain certain aspects of the evidence that had been provided, it was not for Justice Makhubele to say, to put that in cross-examination as if these proceedings are now adversarial proceedings. And this will dovetail with what I suggest Mr. Bishop misconceived yesterday about the presumptions extended to judges. Presumptions are not only extended in the context of a recusal application. It's way more than just looking at the recusal applications. Because if you look at how justices of the Constitutional Court have described the recusal application and what it implicates and what it means, it's just way than that. It suggests that when you make an allegation that a judge ought to recuse themselves, you are essentially attacking the very foundation of what makes a judge. But, you know, before you even accuse a judge of anything, you've got to operate on these presumptions. These presumptions are generated precisely for the reason that judges, while they should be held to account, play a very important role in society. Their legitimacy to perform these functions depend entirely on public confidence in their integrity. And it's easy for organizations who are campaigning on a social issue in their campaign to go beyond what is a legitimate, or to just go in the extreme and throw mud and wood and fire and petrol on something that should not be bent like that. So Judge Makhubele now today is known as state captive judge. How are we going to cure that? How are we going to clean that up? She's known now to be a criminal because she's accused of a crime. How are we going to clean that up? Even if we were to find that on the terms of reference, she cannot be found guilty of the gross misconduct that she's charged with. How are we going to claim the fact that they say that she has a deliberate, which means that in her mind, when she was engaging with the activities of PRASA, she intended for illicit outcomes. How can that be cleaned up? So it's important that, I know I'll come back to the issue of presumptions and why they're important for this tribunal to refer to them when they when they assess the evidence of judges, particularly Judge Mlambo and Judge Makhubele. We do not seek to impugn Judge Mlambo's evidence. We have problems with it, and we'll raise those problems with you. We're not asking you to make any adverse findings on that evidence. In the scheme of things, and in various attempts to manage a crisis, people do forget, and people do get into situations that they can't explain. And I will show why this focus on this meeting of January is really nothing really to be concerned about, unless you consider Justice Makhubele to be a criminal who seeks to lie about everything she said, or that she has a corrupt mentality, that she wants to corrupt the evidence itself. So the first question I want to deal with is why this tribunal must decide the validity of the president's appointments. Mr. Bishop yesterday says it's not necessary for that to be done, and he reflects that even in his heads of arguments. But that misses the point, because in the terms of reference, which are helpfully reflected in paragraph 11 of the complainant's heads of arguments, the question asked is whether the respondent improperly held a dual status as a judge of the High Court, South Africa, and chairperson of the Interim Board of Control of PRASA, and in doing so, rendered herself guilty of gross misconduct as envisaged in section 177 of the Constitution. The question itself requires that you accept the validity of the status of a judge. You accept that so improperly held a dual status, improperly held as a judge and as a chairperson of PRASA. Now, in our submissions, we say she did not hold the position of a judge. How do we make those particular submissions of law without necessarily determining whether or not the two appointments by the presidents are valid? You've got to choose. You can't leave the situation as it is, because it's a constitutional problem. It is a constitutional it's not beyond curiosity. It's a constitutional problem that a judge was appointed twice. It's a constitutional problem, and what you are being asked to do is to give guidance to the JSC on how to resolve this issue. But you can't resolve it without dealing with when exactly was she appointed as a judge. You can't ignore those two appointment instruments that were issued by the president, the presidential minutes. You can't ignore them. You've got to resolve one of them. And then you can say she did in fact hold dual membership or dual status, because there were valid appointments or a valid appointment of being a judge that had been issued, and that is why I think, President, it's important for us to look at very carefully the specific roles that are played by each member of each constitutional agency in the appointment of a judge. It's very important, because it answers the question Mr. Bishop misconceived again yesterday, or misinterpreted, the question of whether judges are employees. No one said judges were employees. We spoke about how you conclude an agreement to be a judge. That is nothing to do with employment. The authorities referred to, I'll establish later on, that the authorities referred to are authorities that relate to circumstances where judges are already in office. And the judge is now in the street, toing, wanting more salaries, or going to the labor court and asking for more money. That's the situation that the context of Van Rooyen. That is the context in which Van Rooyen must be understood. But here we're talking of a situation where there is a candidate who has been offered an appointment by the president. So when the president issues that certificate of appointment, is it open for, let's say it was Mr. Pava who was, sorry to use an example, Mr. Pava, I hope you don't mind. Mr. Pava had now been recommended for a judgeship position by the JSC. And then he discovered that he would like to go farming. Actually, this judgeship is not something that he really wants. He has watched you judges do your work, and he thinks, Norman, it's just too much of a restrictive job. He would like to dance on the ceiling, he would like to dance on the table, and as a judge, it would be a bit funny to see a judge do those kind of things, although I suspect they do. Can a judge, or can a person who has been offered a letter of appointment by the president refuse it? That's the question that Mr. Bishop did not engage with.
You mean a certificate?
Yes, once a certificate has been issued by the president, can somebody who has been issued that certificate refuse it?
I just have this difficulty with the analogy. Perhaps you can clear it up for me. Who makes the approach to be appointed as a judge? Does the candidate make the approach, or does the president ask the candidate, do you want to be a judge?
President Yapi, I think what is important first, let's go to the crux of how judges get appointed, because it will answer that question of who approaches who. What happens is that the JSC publishes vacancies for judicial appointments. Then persons who are interested submit their documents, and they are supported by different interest groups, and they are nominated by different people. The JSC then does a short list of people they think are suitably qualified and should be interviewed. Then it conducts the interviews. Then it makes the recommendations to the president. When they make the recommendations to the president, they say to the president, we've conducted interviews of people we think you should appoint to the bench, and the president then considers the recommendations, and the president would then make the appointment in accordance with the JSC process. Now, this tribunal could improve that situation, the opaqueness of what happens when the president actually gets the recommendations. Let's assume that the tribunal has missed the fact that Justice Makhubele was in a dual status of PRASA and is now sitting with a recommendation from the JSC that she must be appointed. What must the president do? The president would not ordinarily, if he's concerned about that issue, would return the candidate or the recommendation to the JSC and say, well, you recommended this candidate for appointment. It has come to my attention that this candidate is a director of PRASA, and I'm concerned about that. Give me some advice on what I should do. The JSC may well say to Ms. Makhubele or to whoever is being recommended, well, the president has returned your recommendation or our recommendation with questions that can only be answered by you. You did not tell us that you were a PRASA chairperson at the time that you conducted the interview. That's a problem for us. So I'm saying there is an opaqueness in that process. I'm saying, suggesting to you is that as an appointing authority, the president has a latitude to engage with the recommendations of the JSC to the extent that I've suggested, which is to engage with the JSC on their recommendations and suitability of particular candidates. There's also the evidence of Judge Mlambo, which I heard for the first time, that the Ministry of Justice, and Judge JP, having been a JP yourself, would know that. The Justice Department would then ask you, as JP, to indicate when those judges could begin their starting date. Right? If that is the process that occurs, then I would suggest that it's incumbent upon the JP to then go to the candidates themselves and to say to the candidates, I've been asked by the ministry to indicate what dates you wish to begin. Is there any reason why you should not all start in January? And then the candidate would say, well, just JP, the problem I have is that I have a running trial of which I was the only advocate. The trial is midstream. Can I just complete that trial? It's going to take about a month or two, and then I'll be back. I'll come and do the thing. And the JP will say, well, we can give you some dispensation to start late or whatever. But some decent arrangement is made. Because, President Yapi, I think the most important thing is managing the transition of a candidate from whatever position they hold before they become judges to becoming judges. And it's like, what do they call it? It's a truth that cannot be vitiated. That if it came to your attention as either the president or the minister or the judge president, that there was something wrong with a particular recommended candidate that has come to your attention, which was not there when he was interviewed, that you bring it up. That is a duty you have. You can't ignore it. Right? And I'll come back to that duty, because I suggest that to the extent that Judge Mlambo believed that there was something wrong with the appointment of Prasa, there was a duty on him to report the matter to the JSC. But, so here's the answer to the question, President, that you asked. The President, through his Minister of Justice, would request essential information on which to make a full appointment to the position of judge. And I suggest that if that had been done, this would have obviated the problems that Justice Makhubele faces today. If a question had been asked by the minister from the president, when should I appoint them? Then that should have been conveyed to the JP. I know the JP says there's a divisional policy that candidates who are interviewed on a particular day are interviewed on but with respect, the JP has no appointing authority at all. No appointing authority. The appointing authority is the president. So the president then issues a certificate on the premise that the minister, the JP, have given him all the information that is necessary to process a valid appointment that would not suffer that would not be rejected, let's put it that way. So when he or she produces a presidential minute, it's on the assumption that he has all the essential information that is necessary for him to make that appointment. So he does make the appointment with the input of the JP and with the input of the minister, and that should assist the president. So when the president makes that appointment, he then issues the presidential minute. Then the presidential minute is given to the minister then gives it to the JP, and the JP transmits that information to the relevant candidates. What I'm suggesting to you, the panel, is that that process does not take away the right of the candidate to say, no, I do not want to be appointed on a particular date. And where that date has, that aspect has not been raised at all with the candidate before the president has made that appointment, that the president has a duty to look at it upon proper representations to rectify that particular aspect.
Sorry, may I interrupt there, and please don't lose your train of thought. Am I right that what you're telling us now is something that seems to belong in the ideal world, something theoretical, which is not even catered for in the Constitution? But here we have to do with what has actually happened in this matter, resulting in the charges being brought against Judge Makhubele. I hear what you say, but it seems to me that you're telling us the ideal world, how it should be done. And I'm wondering, having regards to our terms of reference for this matter, whether we have the jurisdiction to do that, to correct matters which are not set out in the Constitution or in the rules or wherever. Am I getting you wrong?
If I understood the question correctly, then you're getting me wrong. But this maybe I should ask the question for clarity so that I'm able to be fair to the question you've asked me. What aspect of the submissions I've made do not fall in the Constitution? What aspect of what I've submitted is not catered for in the Constitution? Because I'm submitting that the appointment process, because with respect to Judge Mushidi, one of the things that would have entirely helped this panel was if the evidence of the appointing authority had been called.
Sorry, I missed you.
Yeah, I'm saying that what was also quite missing from my point of view was that the appointing authority, because the question really is about the appointment, whether there was a dual status, wasn't necessary for us to hear from the appointing authority what their view of this legal situation is. It's just, Malega, my senior, explored with Judge Mlambo that question, because he says, well, the documents speak for themselves. The president has spoken through the documents. And you cannot hold that there was two appointments to the judge. So you've got to make a considered reasoning around how to resolve that conundrum. And I'm suggesting to you that if the appointing authority had been brought to present the evidence, you would have been able to ask the questions that you're asking now, which is what happens exactly when a candidate sent to you on recommendations by the JSC. Is it open for you to reconsider one aspect of the appointment that you make, for example, the starting date? Is it open for you to reconsider that aspect? And I say that you have to reconsider that aspect. You have to say, by reference to the Constitution, and I'm not talking idealism or something that is ideal, I'm talking something that's located in the Constitution. And you will see that in section 165(4), and I want to go back because that's the argument we make. Section 165(4) says, organs of state, through legislative and other measures, must assist and protect the courts to ensure independence, impartiality, dignity, accessibility, effectiveness of the courts. Now, if you're about to make an appointment that is inconsistent with judicial independence, as alleged in this case, you're about to make an appointment that is inconsistent with the dignity of the office of the judge. And that can be prevented. Why would it be inimical to the power of the president of appointment to relook at that aspect when that has been properly motivated before him? And I'll come back to the issue that Justice Moshidi raised relating to whether Justice Mlambo should have referred the matter back to the JSC. But that's based on the evidence of Justice Mlambo himself, that if he believed that was wrongdoing, then he should have gone to the JSC. And I think Justice Moshidi is correct on that aspect. But I'm saying when we assess whether or not Justice Makhubele was appointed to commence duties from the 1st of January or from June, we're mindful of the fact that we don't have a constitutional crisis if we interpret the Constitution properly. The president, as the appointing authority, has the power to relook at an appointment that has been made, where it has nothing to do with the fact that, because this is the argument we make. before the president is presented information that was not there. For the first time, the president has made this appointment. He's told, "Oh, President, you've made an appointment of a judge who is unable to begin in January because there are certain commitments that judge has. If we appoint him in January, there will be a problem. That appointment would not accord with judicial independence. That appointment would be wrong." And I'm saying the appointing authority who must make appointments that accord with judicial independence must then relook at that aspect and say, what aspect of this issue are you raising with me? And if the issue is, well, she's not able to commence dates in January, or when does she want to commence? Because remember, according to Justice Mlambo, that question has been asked through the minister, right? And so we don't know, we're having no evidence from the appointing authority what was there before him that would have made him insist on making this appointment. There is an absurdity in making the suggestion that once a president has made the appointment, upon being confronted with the information that this particular appointment does not accord with judicial independence, if it begins on a particular date, for the president simply to say, "No, tough luck, you must just deal with it." There's something wrong with that. That cannot be our constitutional system. That gives the appointing authority no power to correct or to consider representations made to him about why a certain appointment would not accord with the judicial independence if it was carried out at a particular day. Remember, that is not the appointment per se that will not be in accordance with judicial independence. It's when that appointment commences. So all that the judge is looking at is simply saying, sorry, Judge Yapi.
I wanted you to finish, but the question I have is this. In this particular case, because we are confronted with the facts as it is been told to us in this hearing, when do you think the aspect that you are now addressing should have happened? Because according to Judge President Mlambo, he became aware that Judge Makhubele couldn't start, I'm just dealing with his evidence, on the 1st of January when she didn't come in to take the oath. And he was then confronted with the situation, if we accept his evidence, around the middle of January. It was only then that it became clear that she couldn't start on the 1st of January, as far as he was concerned. Now, my question is this. When do you think the appointee, let's call him then, because according to the argument, that person is not a judge. When do you think the appointee should raise the issue that I can't start on the appointed date? It's a question of when.
Yes. Yes, I think I know it would be easier to simply say give a date, but yes. I think it's difficult to give a date of when. No, but can I give a context to the answer I'm going to give?
Yes, so certainly.
Yes. So the moment an appointee recognizes that there is a factor in their life that could bring the assumption of duty as a judge into disrepute, they must raise that aspect. And I suggest that what Justice Makhubele did was that when she, and in fact that letter is very important to have regards to, we all refer to the letter in our heads of arguments, and perhaps I should just go to that aspect. The letter which she wrote on the 4th of December, we deal with in paragraph 3 of our heads of arguments, where she is responding to Justice Mlambo's invitation to indicate a date that would be suitable for her appointment. And her answer is, I had too much reflection on the matter, taking into account all positions that I'm currently occupying. after much reflection and considering every aspect of the challenges, I think it would be better, it would be in the interest of the bench. And I want you to mark that, because it tells you that this person was thinking about the impact her position might have on the bench. She says to the JP, what would be in the interest of the bench is that I start in April. And all the persons that are engaged in the appointment of a judge are concerned exactly by that. What is in the interest of the bench? She, the prospective judge, raises what she believes would be in the interest of the bench. And she says, I think it would be better I start in April because I have certain positions that I am holding now that would clash with my, well, I read that, that's not what she says, but I'm reading that into what she says there. So at that very moment where that is raised, and bear in mind, President Yapi, that Justice Mlambo's evidence is that the minister, although the two versions, one version is that there is a policy that the Gauteng division has, but that the minister approaches the JPs and says to the JPs, when do you want these judges to begin? And then they indicate the dates. Bear in mind that there's that dispensation. We have to be very kind to Makhubele's situation because her situation did not begin in December. The fact that she would not be able to start in January did not begin in December. If you look at the evidence, right at the beginning of her ambition, her step to file her application to be a judge, when she had discussions with Justice Mlambo, and this is from Justice Mlambo's evidence himself. Perhaps I should take you there. Oh yeah, sorry, I've got it here. Right, you will see the evidence begins in chief when she was asked by Advocate Harrison yeah, if you go to page 57 in the evidence of Judge Mlambo, that's this bundle here is called Evidence of Mlambo. I don't know, it's got no volume, but volume 6. Thank you. If you look at page 57, where Ms. Zongo, I almost called you Justice Zongo, so maybe I'm being prophetic. After this interview of 4 October 2017, are you able to explain to this tribunal or outline to this tribunal what exactly then happened after that interview of 4 October? Justice Mlambo says, thank you. I am thinking leading up to the interview, after Judge Makhubele was shortlisted, I recall that she spoke to me. She is the one who approached me to just check what would happen in terms of starting date. Were she to be successful in the interview, I told her that in Gauteng, the divisional policy is that candidates recommended in October should wind up their practices and be ready to assume permanent judicial office by 1 January of the following year. So that is what informed Judge Makhubele. I suppose that is what I informed Judge Makhubele. She stated that she may not be able to start on 1 January 2018. And when I asked her what would be the reason, she said, because I am the chairperson of the Water Tribunal. Then he said, I poured cold water over that. At that stage, I said at that stage, and I mean it was still early, even before the interviews, I said her role in the as the chairperson of the Water Tribunal is judicial office. And I saw no conflict in her doing that work, even if she were to be recommended for appointment or even appointed because as JP, I would make arrangements to give her time to attend to whatever outstanding work there would be in the role as Water Tribunal chairperson. And remember, this conversation is occurring before the appointment to PRASA. So let's not be worried about the fact that she didn't mention PRASA here. At that point, it was the issue of this aspect. But later on, you'll see that her evidence, Judge Mlambo's evidence says, she also mentioned that she had a case in the Constitutional Court, and then he says, well, although she did not indicate when those were set downs and all that, almost suggesting that there had to be an intense discussion about when you're starting, even before the interviews are starting. All I'm suggesting is that right at the beginning of Makhubele's career as a judge, there was a discussion that was very informative about her attitude towards beginning in January. And she made it clear to Judge Mlambo that she may not be. The fact that Judge Mlambo poured scorn on it or poured cold water on it is important, but it's not a very critical factor for the purpose of evaluating Judge Makhubele's evidence further. Because once the variable of being appointed to PRASA came in, that was a new variable in the mix. The first variable was that she was senior counsel with matters before the courts. Second variable was that she was a chairperson of the Water Tribunal. If my recollection serves me well, she was also in the tax board and also, as I say, the Water Tribunal. So when Justice Mlambo writes the letter, the famous letter on I think the 18th of October, congratulating the candidates for appointment, we should not make the mistake of thinking that that was the appointment. The appointing authority was not conveying to the candidates that they'd been appointed. And Justice Mlambo accepts that. Justice Mlambo acknowledges that is the case. Because you can see even the letter as it's written in terms that suggest that there's still a position that the president must take, which would confirm whether or not they have now been appointed. And when that letter in October is written, Ms. Makhubele, writes to Justice Mlambo and says, yes, thank you very much, but there's this issue that I need to still discuss with you about my starting date. That's a conversation that had already begun before she started her duty, the interview. So you can see that in her engagement with Justice Mlambo, there was this one variable that was troubling her, the starting date. And may I suggest that Justice Mlambo, on receipt of the letter or call from the ministry on dates, had he taken it to Justice Makhubele, in light of the discussion they'd had at the beginning, to say, when you were, just before you took up the position, you indicated that you may have problems in starting in January. Do you still have those problems? Because I'm about to recommend to the president that you are appointed from January. You've raised this issue of I need us to discuss the issue of when I start.
Now, when we get to the question, when do I start, as you put it, what is she raising with Judge Mlambo that he should have taken into account? Because apparently what was raised at that time was not her position at PRASA. It was positions not involving PRASA, which, according to Judge Mlambo, were not barriers or impediments to her taking up the appointment in January, as he had testified. Just dealing with Judge Mlambo's evidence, the first time he regarded the PRASA appointment of Judge Makhubele was when he spoke to her in the middle of January. That's his evidence now. And that's when she made it clear she couldn't take up the appointment on the 1st of January. His evidence is then he wrote to the authorities saying, well, it looks like she can't do it. Now, the question really is this, and it's important. When did her position at PRASA become a matter for Judge Mlambo to consider, because we are now going into what Judge Mlambo did, to regard her as not being able to start on the 1st of January? Was that before the 1st of January, or was it after the 1st of January?
I have two answers to that question, President Yapi. The first one is that the determination of whether her position in the Water Tribunal or her position in any other tribunal or any other board or any, her position prior to being appointed, the determination of whether that conflicts with her duty as a judge must be made entirely by the person who must decide that. In other words, it was for Makhubele to decide whether or not, despite what the judge president thought about the issue, ultimately the person who must decide whether that position is a position that places her in conflict with her duties is Judge Makhubele. The JP can express a view on it, can give advice on it, but the person acting independently, acting as a judge should, including getting advice from the judge president, would be the judge concerned. So I accept that Judge President Mlambo testifies that the first time he got to hear about this is in a meeting he cannot remember, sometime in the second week of January, that the first time the issue of PRASA came on board. But I'm suggesting to the panel that it is entirely for evaluating whether there's gross misconduct or not, the position that must be taken on whether there is a conflict with judicial duty has to be that of the judge. It's like when I asked the Judge President Yapi to recuse yourself. You must decide that question. It can't be decided by Justice Moshidi. Even if Justice Moshidi or could say, no, I think the question that they're raising is valid. The ultimate arbiter of that question is yourself. And we suggest that the ultimate arbiter of when it was in the best interest of the bench for her to begin her work was Justice Makhubele. It was not the Judge President. The Judge President could disagree with her, could give her advice, but if Justice Makhubele's conscience as a judge, if her conscience as a judge did not allow her to accept the proposition that as a chairperson of the Water Tribunal, she was performing nonetheless a judicial function, and that therefore there was no conflict with her assuming judicial office. If she didn't believe that, that is the end of the issue as far as we're concerned. The second answer to the question, and this will also take us to the evidence of, and I want to take time to deal with the evidence of Justice Mlambo, just to prove that the evidence of Justice Mlambo is not what has been made to look like here. And I will not make submissions that are demeaning of any of the characters that are involved here. But with respect, Justice Makhubele's evidence is that she then, when she had indicated to Judge Mlambo that she preferred January, Judge Mlambo wrote back and said, it's your something about your undoing.
If I may be of some assistance, I recall him when he received the letter of the 4th of December. He said, well, it's too late now. Some words to that effect.
Yes.
Yes, and then there's the meeting, either the 14th or the 15th of December.
Right. Right. So that's the 6th December response where he says the delay has been your undoing, unfortunately. The President has already done the appointment with effect from the 1st of January 2018. I'm awaiting for the appointment letters and certificates. We can meet next week or week after next. That's how it's put. So let's accept, which Makhubele does not accept, that there was a meeting, the physical meeting between Justice Mlambo and herself and Deputy Judge President. This is how the evidence goes, and we have to be very meticulous in looking at the evidence of Justice Mlambo when he deals with that particular aspect. And I want to refer to Justice Mlambo's evidence when he was being cross-examined by my learned friend, Mr. Malega. So the questions by Advocate Malega starts on page 98. Right. So he explores with him a number of issues. I'll return to those to the extent they become relevant when questions arise. On page 101, Malega says, yes, can I ask you then to look at your response that was in response to the letter, the complaint from the complainants? And he points him to the paragraphs. Do you inform the complainant that you have requested that the appointment of Judge Makhubele be with effect from 1 April 2018? He says, correct. Then he says, we'll come back to precisely what is the purpose and import of the date of commencement of office upon appointment as a judge. You say that that request of Justice Makhubele, the request for the taking effect of office was a request coming from Justice Makhubele. Justice Mlambo says, yes. Again, I would like to later on take you through correspondence, simply to explore the fact that that Justice Makhubele made no secret about communicating a request to you. Yes. If it was an open request to you, she did not conceal anything relating to a desire to start from 1 April 2018. And then Justice Mlambo says she concealed her PRASA appointment. Also, that is awkward to say that she concealed her appointment when the appointment was widely reported in the newspapers. But we'll leave it at that. I mean, I'm not suggesting that means Justice Mlambo wanted to hear from the mouth of Justice Makhubele that she did not. It's quite tough to say she concealed her appointment, which suggests that there was a deliberate intention to conceal that she was appointed. But I'm not there yet. We will get to the PRASA issue because all it seems to me that you suggested that it is something that had worried you. And Justice Mlambo says, yes, it worried me. I will come back to it later when we talk about the correspondence you directed to the Minister. You directed to the Minister of Justice, but suggestion is that she concealed that fact from you? He says, yes. Once you learned about it, did you regard it as something that affected the suitability to occupy the office of a judge? Justice Mlambo says, I voiced my displeasure in the meeting. Maliga says, no, I understand. Mlambo says, yes. The point is, did you regard it as something that affects the suitability to occupy the office of a judge? And here is the answer. Yes, I would not have voiced my displeasure had I not held that view that she had rendered herself unsuitable by joining a litigant who was featuring in the division. Maliga says, can I interrupt myself here and take you to a letter that you wrote to the Minister of Justice? That is on page 22 of the same volume. They go through the letter. Then Maliga says, is it the letter that you write to request the minister, the then minister, Masuta, who is the Minister of Justice and Constitutional Development as then known, that a date of commencement of office be deferred? Justice Mlambo says, yes. And by that time, you had known that she was acting chairperson of the interim board of PRASA. He says, yes. You mentioned the reason why you requested the deferral in paragraph 2. And he reads, Madam Justice TNA Makhubele approached me after I had notified the Ministry of Appointment, the Ministry of the appointment date of all newly appointed judges of this division. And just note there that he says he notified the Ministry of the appointment date. Bearing the argument I'm putting to the panel that issue of appointment date had been an issue raised by Justice Makhubele with Judge President Mlambo. She will require a few more months to fulfill all her tasks as the chair of the Water Tribunal, and it's kindly requested that her date of appointment be amended to commence on 1 April 2018 instead of 1 January 2018. And then the evidence goes on. It says, you do not mention in that paragraph or elsewhere in the letter whatever concern you may have heard about her involvement in PRASA. The Judge President says, no, I did not. I take it that there must be a reason why you did not disclose that in the letter. Justice Mlambo says, I think, as I said, her official reason to me for wanting to start in April was mainly her water chairpersonship. The PRASA issue came out because we extracted it out of her. It is something clearly that told us that she did not want to talk about. Maliga says, no, I understand, but the point is, at this stage, when you write to the minister, you are aware of her involvement in PRASA. He says, yes, yes. The point really is that you do not tell that to the minister as one of the reasons you requested deferral of commencement of office. Justice Mlambo says, that is correct. There has to be a reason why you did not tell the minister of that matter, which is, in your view today, was a concern to you. He says, yes. Then Maliga says, I respectfully suggest that the reason why you did not disclose that fact to the minister is that you did not consider it as a matter that affected the suitability to be and to remain in office as a judge. I suggest to you why that is so obvious, because what you request is for her to remain in office, but to start later on. So by that logic, you still regard her as a judge suitable to serve in office, but only from 1 April. Yes, so you want a response. Maliga says, maybe the tribunal will be interested in a response here. Mlambo then says, I think I have tried to illustrate that it was us who extracted the PRASA issue out of Judge Makhubele. She did not want to place it on the table of her reason for not wanting to start in January. Her official reason was her Water Board Tribunal chairpersonship, and that is what I put there. Yes, I had concerns. That is why I expressed them to her in that meeting, to say it is unbecoming of her to join an entity that was featuring in the division in litigation regarding alleged corrupt tendencies, and then come back to the division as a judge. Judge Mlambo, we will get to the date on when she took office, yes. For now, I do not want to repeat myself. All I'm saying to you is that a matter of momentous concern to you was not disclosed to the minister in this letter. Justice Mlambo says yes. can I get back to where I was before I interrupted myself? Then he goes and he says, he says I was at page 33. In paragraph 4, you in response communicate the following further matters to the unite behind. The first is that Justice Makhubele had not taken oath of office as at 29 January 2018. Correct? He says yes. I suppose that's what Malega then says too. I suppose that is what we casually call the oath of office by judges before they commence their duties as judges in Schedule 2 of the Constitution, and there's a reason why judges are required to take an oath of office before they serve as judges. Before I suggest any reasons to you, would you be able to offer your own understanding of what the reasons are for judges to take oath of office before they commence with their judicial functions? And then Justice Mlambo mentions those reasons. And if you go further, he quotes from the letter and he says, this is Malega quoting from the letter in the middle of 217. Thank you for that. Then you can go on and you say, she has not been paid any salary as a judge. That's the Mlambo's letter to the complainant. I do not know what further evidence we will have as the proceedings unfold, but my instructions are Judge Makhubele never claimed any salary before she took office from the 1st of June 2018. Would that be consistent with your understanding? Yes, she never claimed any salary. It is because she did not sign the forms that would have authorized the salaries units to deposit money into your account. Malega then says, yes, there is a reason why she did not claim salary until she took office in June. It is because of the fact that she did not regard herself as a judge. Do you want to comment on that? Then Judge President, in fairness, says, that is her view, but a small correction of that narrative, Advocate Malega. At the end of March, she was ready after her discussion with Justice Skosana, with Advocate Skosana, to submit forms to start getting a salary. Indeed, yes, as we will look at the correspondence, it becomes necessary for us to go there. Now, I would urge the tribunal to go through this evidence carefully, because here is the problem with this evidence of Judge President Mlambo. Judge President Mlambo has just identified from a judge, has just identified or expressed serious concerns about the judge's suitability. He's gone as far as saying he doesn't think that she was suitable. Now, I submit that if any of the judges, not just the judge president, any of the judges discovered that a judge had committed what would be called misconduct of a minor or major issue, that judge has a duty, it is a duty consistent with the office of that judge to raise that issue with that judge. In fact, the Code of Conduct says you first raise it with the judge concerned. And of course, after you raise it with the judge concerned, and there are no agreements or there are problems, then you take it further. That is an obligation on the Code of Conduct. Now, Judge President Mlambo has just discovered in her terms, and I don't want to go to I'm just urging the tribunal to look at the evidence very carefully. You will see in that evidence that there is a worrying inconsistency. Because if Judge Mlambo had discovered that at that point of talking to Judge Makhubele, there were two things that were bothering her. She was refusing to take an oath of office. Secondly, that means she was refusing to assume duty. Secondly, the reasons she had given, according to Justice Mlambo, is that she wanted to, and this was paraded quite a lot yesterday, please, Minister. The reason was a very awkward reason that is given. But that's what Judge Mlambo has just discovered. And Malega is correct, Advocate Malega is correct when he says it was a momentous issue, an issue of grave moment. Judge President has just come to contact with information that makes him conclude that this particular individual is asking to take out of office, is actually not fit for the office. And that's why Justice Moshid is correct, that the way to have done it was to refer the matter to the JSC at that point. But that's not what Judge President Lambo does as Judge.
The argument that you're now advancing goes to the conduct of the Judge President Lambo. What we are concerned with in this tribunal is the conduct of Judge Makhubele. What does that all say in your submission about the conduct of Judge Makhubele?
Firstly, even though President Yapi, you mentioned that we're concerned with Judge Makhubele's conduct. We're concerned about Judge Makhubele's conduct from the perspective, from the eyes of those that talked about that conduct. And we're evaluating what the possibilities and what the probabilities were. But the fact that Justice Makhubele refused to take the oath of office is consistent with the position that she was not a judge. And it's entirely consistent. Her attitude, if what is reflected by Judge President Lambo is correct, and we have no reason we have difficulties with it. We think it's a different date that discussion may well have been had. But if we give a benefit of the doubt, that discussion tells you that Justice Lambo was having a discussion with somebody who believed that she was not a judge.
Well, what you are suggesting, whether she was a judge or not, which is an objective position, but subjectively, she believed she was not a judge. And in support of that belief, you point to the conduct of Judge Mlambo, who also believed that she was not a judge at the time. Am I correct?
No, well, let me just be careful how I understand you. Because if what you are putting to me, President Yapi, is that the belief of Judge President that she was not a judge in a condemnation sense. You didn't mean that way. Okay, so yes, I think at that point, we then can agree that Judge Mlambo was concerned that according to him, that she was refusing to take the oath of office. According to him, there was pressure that was brought to bear on Judge Makhubele to take the oath and to come on, get on with it. In fact, the evidence is also that Deputy Judge President Ledwaba weighed in and said, but why can't you just resign? Just get on with it, And she said, no, I'm not doing it. And I'm putting to the panel that at that point when she said no, she was saying, I am not a judge. If I take the oath of office when I'm not a judge, I'm just committing a cardinal error. I've just said to you, I want to be appointed on a date where that would conflict with my other position. If I do this, this will then put me exactly where I don't want to put myself in.
No, what I'm suggesting, following your argument, that she was not alone in her belief that she was not a judge until she took the oath. And you say this seems to be supported by the way Judge Mlambo went about dealing with the matter. Have I got it correct, or do you wish to put it any other way?
Yes. No, I want to qualify my submissions in respect of what Judge Mlambo's belief was. Because Judge Mlambo's belief seems to suggest that he believed that she was a judge from January. In fact, his evidence is that he was a judge from January.
That's where I'm going.
Yeah.
If he believed that she was a judge from January, then why would he get involved with further correspondence with the minister as such?
Yeah, that, well, I think that's a question that answers itself in a way. But more than that, one has to look at the letter and ask the question, if it had come to the attention of Judge Mlambo that there were some problems of the nature that should be serious problems of Justice Makhubele, which is what Judge Moshidi was saying, the proper route was not to write to the minister. The proper route was to go to the JSC. But we accept that then what he does, Justice Mlambo, is to write to the minister and to say to the minister, Minister, Justice Mlambo has requested that her appointment be relooked at. He uses many words, deferred, there's another word, revoke, and all those kind of words. But here is the issue. Once that has been triggered, and we suggest that Judge Mlambo's actions were quite correct, to write to the minister and to say to the minister, Minister, I gave you a date that all the judges are coming in January, but there's one particular judge who is not able to commence in January. Can we have a deferral of the issue? And you will see that when managing that transition, that process, the minister quite correctly gets a legal opinion. The legal opinion is a legal opinion, so I don't particularly agree with it, but it concludes that only because it's one aspect of the appointment process, the president is not snookered out of relooking at the issue and issuing a new determination. So the tribunal ought to be, we have to accept that when the president relooked at the issues, he was not relooking at the issues on the premise that there was a valid appointment. And I cannot imagine that when President Ramaphosa started looking at these questions that were being raised by the minister and the JP and all those questions, that he was simply looking at only those. He must have looked at the JSC report too. And the interview of Justice Makhubele was riveting. Even the complainant, angry as he is at Justice Makhubele, had nice things to say about Makhubele before appointment. When she did her interviews, it was one of the best interviews that were done. It was a story South Africa should hear over and over again. They say so themselves. They were quite happy to have a woman who had struggled through would really move through the mountains to get to where she was. It was a beautiful story. So the president must have looked at all that and issued the appointment that she starts on the 1st of June. So we want to submit that to hold that she was a judge from January creates a constitutional, I have a word for it, which is in the heads. It's in the heads. I can't remember the word I used, but it creates a constitutional absurdity. And the absurdity there is that the president can't appoint the judge twice. You've got to give a proper interpretation of what was engaged in that process. And this is where I think it's important that the evidence leaders should have brought someone from the presidency or the president himself, if that was required, to explain that particular position. What did you consider? There was already an appointment, but how did that appointment affect your thinking over these issues? And the issue would be no, but an appointment had not been accepted. That appointment of President Zuma had not been accepted. And what was being negotiated through all the functionaries that are involved in the management of the transition from being a non-judge to a judge was to make it sure that they do it in a way that meets the requirements of the Constitution. Avoid making a constitutional appointment of a judge that is inconsistent with the Constitution itself.
Same topic, but just a different view. What do you say should have happened, Mr. Masuka?
I was hoping you'd ask me that question, President, because I think that's where Judge Mashidi said the idealism. But this is constitutional idealism, which is not really ideal, but which is anchored in the Constitution. What should have happened is that the discussion between Judge President Mlambo and Judge Makhubele should have been given a bit more attention. And it seems to me things were left too loose to the end. And part of it is that Judge Makhubele did delay in answering Judge Mlambo. But to be fair, the issue of her difficulty in starting in January had been raised with Judge Mlambo. And if there had been a request by the minister from the Judge President to indicate the date on which judges who were appointed for that division should start, it would have been ideal for the Judge President to have called Makhubele and said, the minister has just asked me when judges should start. We have a policy that they start in January. You raised the possibility that you may have problems in January. Do you still have those problems? And if she said, yes, Judge, I still do have those problems, then he would have said, okay, fine. When do you want to be appointed? April. And then it would have been conveyed before the first presidential meeting, the minute was, before the 1st of January, would have been conveyed to the president that, oh yeah, there's a judge who wants to start in April. And the presidential minute would have reflected that minute. So these were measures that were necessary to be corrected, and wherever the lapse lay, these were measures that were necessary in order to correct an appointment that could have created problems for the judiciary. And we accept from Makhubele's own mouth that she viewed that her appointment in January would not be in the interest of the bench. And that's a very important observation. And so that would have been the ideal process to follow, and I submit that would have been the constitutional position to follow. Now, but the second issue is this. Now that that process I suggest should have been the process was not followed. In the event the president had issued the presidential minute appointing Justice Makhubele for the position to start in January. I submit that it was open for Judge Makhubele to refuse that appointment.
Again, same topic, but different aspect. Having refused the appointment for the 1st of January, would that have necessitated another interview by the JSC? Or could the president on his own simply says, okay, I accept the refusal, take another date? What do you say the position is?
My submission is that the position would be as follows. If it was conveyed to the president that there were difficulties in getting a judge to be appointed in January, it was open to the president to say, no, but I can't. I insist that that position be taken. I'm not changing the date of appointment. I'm not changing any aspect of the appointment. I've done the job that I need to do. I've accepted the report of the JSC. I've accepted the presentations made to me through the minister of when they should begin, and I'm not moving. So Judge Makhubele or any judge in that position should commence duty. And if in those circumstances, if Judge Makhubele then refused to take the position, having been told that the president was changing any aspect of it, then we could start talking a different thing. Because then the president essentially would have put her in mora, almost put her in a position where she must say yes or no. Because the option for Justice Makhubele is to say, okay, I'm not accepting the appointment of January, please, I'm going back to practice. And the president would then write to the JSC and say, Justice Makhubele was not able to accept the appointment for reasons that she was engaged in other things and she couldn't take the appointment in January. When she approached me to say that she wanted a deferment, I refused for these reasons, and she decided not to take the appointment. Right? And the JSC would then give the president maybe more recommendations, or an appointment is simply not made.
Well, the president has got wide discretion in terms of the Constitution.
the
to appoint or not to appoint. Section 165 you referred us to.
Yes, that's what we suggest, that power enables the president to only make appointments that accord with the law. So if it's been pointed out to him that there is or to her, that there is an appointment that might conflict with the integrity of the judicial office, that must concern him. And he must Now, there's a other side of the argument, which my learned friend from Cape Town, Mr. Bishop, has, which is that the functus officio argument, that once an appointment is made, it's made for life, and that's it. You take it or leave it. That's it. That can't be a rational interpretation of the power given to the president to appoint. It cannot be rational for the president to be forced in a situation where, after having made an appointment and representations are made to him, that a certain appointment could be better off made. Because what was not being taken away from Justice Makhubele was a suitability as a judicial officer. That wasn't being taken away from her. And we know that because Justice Mlambo studiously avoids setting out his views of what he thinks the PRASA appointment places her. And so when the appointing functionaries are engaged with this issue, they don't have his mind of what he thinks about the PRASA appointment. They don't have that. So when they engage with the issue, they engage with the issue at the level of saying, no, they want, the suitability question is out of the question. She is suitable to be appointed. The only issue is how do we manage that appointment in a way that does not place her in a position that she's not able to perform her functions with the independence that is required in the Constitution. So we have to accept that the president should. The JSC's position as a recommending authority and as a disciplinary authority, it sits differently. And if Justice Mlambo had sent a complaint to the JSC to say the recommended candidate subsequently took a job or took a position in the PRASA, and then there were these problems, and I have these problems, I have this complaint, the JSC would have to look at it. And one of the things they would say is, but Ms. Makhubele, you took that position, and they would ask the same questions that we asked here about the wisdom of having taken that position. But that would be in the context of where we are now, the context of a disciplinary process. But it would be you would be denuding the power of the president to appoint if you were to suggest that is functus officio. And as we submit in our sets of arguments, is only functus officio when the candidate walks into the judge president's office and takes the oath. Because at that point, it's non-revertendo. You can't reverse it. You've triggered the power of judgeship is now fully enclosed. You're fully anointed, if we may use those kind of words, to become a judge, and you can start acting as a judge. So the fact, if one accepts that you can actually refuse an appointment, it was open to Judge Makhubele to write to the president to say, President, thank you very much for the offer. After considering a number of issues, I've decided not to accept it. There would not be a judicial misconduct complaint against her on the basis that that appointment was valid, and she then rejected it. Thank you, Judge. Thank you, President. Now, we've dealt with...
Sorry, before Mr. Masubu moves on, the argument, I want to revert to the argument you submitted before this main argument.
Yes.
Remember, you said that Judge Makhubele should have been allowed to have the last say as to when she wants to commence working. Final arbiter, I think you used that word.
Well, I may have overstated the point, but what I meant really to Judge Mushidi, and I think you are correct to correct me on that. When I say final arbiter to decide when she starts, I don't mean that that's cast in stone, because the example I'm giving now is that if she were to say to the president or the judge president, I can't start in January, and the president said, I'm not changing anything, your appointment starts in January, and then she refused, then that would be problematic. So I'm saying that part of what attracted the JSC to recommending Makhubele to be a judge must have been her independence in deciding whether it was in the interest of justice, or sorry, in the interest of the bench, for her to be appointed in January because of the responsibilities that she still had to carry out. I think that's what I'm trying to say, Justice Mashidi.
Yeah, because I was just wondering if that had to be allowed, and in the context of the evidence of Judge J.P. Mulambo, and also his evidence about the shortage of judges at the time. If all successful candidates would come back and say, I can't start on this day, one can imagine the administrative chaos that would happen in a division as busy as Johannesburg and Pretoria. If every candidate was given the latitude to say, no, not me, not this month, next month, and so. Judge Mulambo did testify about the shortage.
Yes, he did. I recall that evidence.
Got acting judges,
Yes.
and,
But I think it's important that maybe I reformulate the submission. I want to be very careful because I don't want to be understood to suggest what you put to me now and what was testified to by Judge President Lambo.
But I'm not wrong.
No, you're not wrong. But what I'm saying is that there are scenarios, and Judge President Yapi would have confronted that in his position as Judge President, where a judge is appointed and the judge accepts the appointment, comes and takes the oath of office, but is unable to assume office because their mother is not well, or there is some other vitiating, there's something that just makes it difficult for them to start exercising the authority of a judge. And that's a different position, because that's administrative intervention that a judge president takes. But here is a question that the scenario I'm postulating is when a person is not a judge in the sense that they have not accepted the position of the offer of appointment. Where the person does not accept the offer of appointment.
Well, that's a different thing entirely.
Right. So where a person does not, where a person accepts the offer of appointment conditionally, we know that in contract that's not an acceptance, and that will also fall under the rubric of rejection of the offer. So all I'm suggesting is that there are two different scenarios that we're dealing with. One scenario is when do you become a judge? The other scenario is when you are a judge, can you be given time, as Justice Lambo says in his evidence, to finish up certain things, outstanding issues that you're doing. One thing I know for a fact is that you would not give counsel after having taken the oath of office to appear as counsel before any court. You wouldn't, because that in itself would be in conflict with your duties as a judge. You would not, but if counsel were to say, no, you know what, I've got a criminal trial that is going and da-da-da, can I be, and that is in the scenario postulated earlier on, when the judge gets to know that information, then he conveys it to the appointing authority. There's one judge here who may not commence on the 1st of January. Can you accommodate them for the appointment in the next month or 2 months later? Sorry.
Something is not coming out strongly. Judge Makhubele indicates that the date that I can start is the 1st of April. J.P. Mulambo comes back to Judge Makhubele to say the train has moved, if I may put it that way. It's your own doing. The president has appointed or issued out the certificates for the 1st of January. I don't hear your argument in terms of what happens or what should have happened thereafter, after it has been conveyed to her that your date is the 1st of January. There's something missing that I don't hear. What should have happened? You have indicated the scenario of what should have happened when the appointee is unable to take up the position. Let's say, okay, it's fine. The president has been informed, or the appointee has been informed already that the date that you want. What is it that JP Mlambo should have done? Or what is it that Judge Makhubele should have done?
Sorry, I think it's probably a good time to ask for a break, but I intend to, if you don't mind, just as a precursor, I do want to understand you, I do want you to understand my argument. So if I'm not clear, then it's important that you ask that question. So if it's okay, can we take a break so that I attend to that question more fully after the break?
Yes, we will then adjourn for tea. We will take a short adjournment for 15 minutes.
Thank you, Judge. draft roster, a duty roster which Justice Mlambo issued, and that roster is referred to in the letter of the JSC by one Mr. Chilwane, in which he says that the roster that was circulated was in fact inadvertently circulated, and the official who had done so had actually been reprimanded. After that letter, Justice Makhubele wrote to Judge Mlambo and said to Judge Mlambo, please put my placement on the roll on hold until we have this discussion about my starting date. You recall that? Yeah. But I think it's probably better to speak through the evidence in the transcript. If one goes to volume 6, I recall from page 159, you will see there your question was locked on the evidence given by Mlambo on in that first paragraph. I think we can take it for record purposes that she was more forthright in an email of 4 December when she said, I've thought long and hard because I've written to her on the 23rd of October and said, well, put on email what your reasons are about that matter. And she did not come back to me. She only came back on the 4th of December to say I can start, and still not say why and what, and that is when I responded and say, well, unfortunately for you, the president has already appointed you. Yes, and Maliga then says, Judge Mlambo, just to follow up on your response, one of the questions put to you by the chair, about when did you pick up Judge Makhubele's indication on the question of the starting date? And he says, I would like to make sure your evidence is captured correctly on this issue. May I ask you to go to page 6 of the same bundle? At the bottom, obviously, comes with her. We have dealt with it yesterday. And then it goes further and says, and can I ask you to look at paragraph 2? We've established that the email comes from on October 20, and then which is 3 days or so after your directive, and she says, I would like to have further discussions with you regarding the starting date of my appointment. Do you see that? And he says, yes. So I take it that you are aware that she has some issue to raise with you regarding the starting date, as early as October, yes. I'm aware, I mean that discussion started before the interviews. It confirms again that discussion started before the interviews. Maliga then says, Judge Makhubele has tasked me to place this on record and ask you to comment. That when she asked you, she talked to you about the inability to take office on as 1 January 2018, she did indicate that she was also involved in a matter where she was senior counsel leading a junior in the Constitutional Court. Then Judge President Mlambo says she mentioned that, but her main reason was with the tribunal. And when I asked for her if there was a date, because I said if there is no date, that cannot prevent you from starting. Give over the brief. And then says yes, yes, I understand that she did raise with you the fact that she has an appearance to make in the Constitutional Court. Then Judge President Mlambo says, if there was a date, and there was no date, she mentioned that that is correct. Yes, then Malega says, Judge Makhubele has also asked me to place this on record, that when she met you in December, so she refers to a meeting in December, you did talk to her about the question of the court role that you had prepared or will be preparing. Do you recall the discussion between you and her in December, or the question of the court role? Judge Mlambo says, no, I do not remember us talking about the court role. Then Malega says, when she testified, she will deal with her recollection of the meeting. And then Malega goes ahead and says, where according to her, you talked about the court role, and she would indicate that on that discussion, you did reassure her that you will rearrange the court role. Then Judge President Mlambo says, no. There was no issue of me rearranging the court role because her name was not there and I expected her to start, and I expected her to come and take the oath. So no, I do not think the discussion happened about me rearranging the role, because nowhere in any of these papers is there any indication that she asked me to rearrange the role for her. Is there indication that she asked me to rearrange the role? And then Malega goes in and says, all right, we now know from your evidence. That is as of 1 December, Judge Makhubele did not take up office. Mlambo says 1 January, yes, 1 January, my apologies. Did she come in to take the oath? No one was expected to perform, no, sorry. Then Mlambo says, she did not come in for the oath. No one was expected to perform any duties until the start of the term, which was later in the month. That was in reference to whether she could have come in January to take the oath of office. And then, and you did arrange for acting judges, and one of whom was to take the role that you were designed for her. But that was later in January. I understand, not in December. I understand, and that is where I would like to explore. So in January, did you rearrange the role? Then Judge President Mlambo says, yes, as an acting judge. Yes, but I think, let me make sure we do not lose the context. This was after that meeting where I had to recall her to say, why have you not come to take the oath? On your recollection, when would that meeting have happened? I think that meeting happened anytime from the second week of January. For the second week, then Malega says from the second week of January. Then Judge Mlambo says, I can go back to my diaries, but it is going to be a laborious thing. Right? I think what is important there is that Judge Mlambo himself does not recall a specific date, and it's discussed there in the evidence that he didn't recall the specific date, but he recalls vaguely that somewhere in February, in January, there was a meeting. And then he says, Malega says, no, certainly we would not be holding you to a specific date. We just need an indication. And the point of the estimation we're looking for is that in January you did arrange for an acting judge to take over the role. Then Judge President Mlambo says, after I met her and got the clearest demonstration that she's not prepared to do her work as rostered. And when did that acting judge, I think it was Judge Wanless and Mayor, when did one or both of them take office? They took office after they were appointed as acting judges, actually the same role that Judge Makhubele was in. Is it fair to say that they would have taken office in January? Yes, in line with the roster that I had issued. We can go back and check the roster when the term started, you know. And then there's a discussion. So, I mean, the question really is that there's interaction between Judge Makhubele and Judge Mlambo after the 4th of December, when Judge Mlambo said, unfortunately, the president has issued. Remember, Judge Mlambo was very gracious to Judge Makhubele because he never closed the door on her. All the communication that we've seen, he did not close the door on her to come and talk. Even the letter that she wrote to say that the president had already made the appointment. He says, let's talk. Let's meet later on. Of course, the meeting would have been about exactly that point, that she's not able to start the position. And then, can I then go to 133? But I see that you want to ask me a question. Perhaps I should take your question first.
By the 4th of December, when that information is conveyed that the president has already issued the appointment certificate, what I'm interested in, remember prior to that, the reasons why she can't take were conveyed, and the PRASA part was not indicated.
Yes. Can I ask, why is the PRASA part an important factor in your estimation of the evidence that she didn't convey that aspect in December?
It's because the questions, or the answers that were given were that, no, those will not be a problem. The Water Tribunal will not be a problem. The Constitutional Court matter will not be a problem.
Yes.
So that's why I'm interested.
Yes.
What could have been the
It's at some point between Judge Makhubele and the evidence, whichever version you take, there is clear indication that there is interaction between Judge President Lambo and Judge Makhubele, right? Judge Makhubele becomes chairperson of PRASA sometime in October, if I'm correct. And your question is why, when she never told Judge President Lambo that she was at PRASA. I don't know what to make of that. The point I'm making is that the discussion starting on January started even before she came to PRASA. And the fact that Judge Lambo's view was that the Water Tribunal issue was a non-issue in my submission is irrelevant. The person who should make that decision is Judge Makhubele herself. The fact that Judge President Lambo had a view of it is important, but not a relevant factor. At some point, the issue of PRASA came up. So it was not an issue hidden anyway. It was a public appointment. It was reported in the newspapers. And Judge Lambo says he heard about it in the papers. He just wanted her to come out with it in a meeting. And I asked for what reason, why if he was concerned about it, why couldn't he raise it himself? So who raised it, who didn't raise it, should not be an issue. And you have to be very, I know that my learned friend, Mr. Bishop, suggested yesterday that there were credibility findings made against Judge President Hlophe. It's incorrect. I was involved in the case, so I know that the judges preferred, the tribunal in that matter preferred the evidence of the Constitutional Court justices. They make no adverse finding whatsoever on Judge President Hlophe. No adverse, not one adverse finding was made against him. And that was part of the complaint we had going further, which was that, but if you didn't believe Judge President Hlophe's evidence, you didn't disqualify it as being a lie or improbably, why then did you prefer the Constitutional Court judges? Because now you have left both versions credible. But we understood why they did that. Because it's not necessary to go into credibility findings of a judge if it's not necessary to do that. Judge Mlambo, you'll see that in many places where Judge Mlambo says, I don't remember, like I've just read to you a portion where he says, I will consult a diary. He never does come back to say, I've consulted a diary and this is what the effect is. He doesn't really remember, and I'll read something again from from 133, which shows that in the interaction between Justice Mlambo and Justice Makhubele, there was a level of informality that was based really on their relationship. She would call her Nana by her name. She never called her by different names. I mean, he would call her Nana just to show that the relationship was pretty an informal relationship. And you will see that the Judge President did not testify here with a minute book where he said, no, we sat down, we had a meeting, we took minutes, this is what the minutes reflect and all that. There was a level of informality, almost consistent with collegiality that goes in between judges. So when there are versions that do not meet, we should not be excited about them. We should just look at whether it's reasonably possibly true that these versions are genuinely inconsistent, but they're not reflective of one telling a lie and the other telling the truth. It's just a matter of, can they recollect their matters properly? And in this case, page 133, from 133 of volume 6, This is where the very question that I'm just Ms. Slevu asked, where Malega says, then I ask you to go page 99, and then you respond to Judge Makhubele's email of 4 of December, and again you say, hello Nana, thank you for your email. The delay has been your undoing, unfortunately. The President has already done the appointment with effect from 1 January. I'm waiting for the appointment letters and certificates. We can meet after next week. Now the question which I want to ask is flowing from that. The pro forma prosecutor asks, are there any meetings that took place between you and Judge Makhubele after email of 6 December? And Judge President says, I cannot recall. And then Advocate Malega says, Judge Makhubele has instructed me to indicate that you met with her at your office after this email. Would that be something that is consistent with your recollection? And Judge President Mlambo says, as I say, I cannot recall if there was a meeting. If she says there was a meeting, I will not dispute it. And you can see, that is why for me it's very important that we not rush into going to finding credibility questions, because it's clear that there was the level of informality in these interactions are such that one person could remember a meeting and the other doesn't remember it. It's possible from the evidence. Judge President Mlambo says he can't remember this meeting, but he cannot dispute it. And then Advocate Malega says she will tell the tribunal that there was a meeting between you and her after 6 December. My apologies, 2017, thank you. Chair, I see that it's 4 o'clock, and then of course there's a closing. So I'm just saying, on this sequence, and just dealing perhaps finally with the issue of the recollections of the January meeting, according to Judge President Mlambo, I think I've dealt with that extensively. All I want to say about that, the evidence of Judge Mlambo, is that there are 2 alternatives to that. He's probably correct in content of what was discussed. But his recollection of the content of what is discussed is correct. But what is not correct appears to me to be the date. Because if then you go into dangerous territory, because you then have to explain how Judge President Mlambo, in writing to the minister, omits very critical information relating to a judge who is refusing to take the oath of office, who has pressed to please a minister, and all those questions. Then you'll have to explain that aspect. Judge Makhubele's recollection is that it's in March. Judge Mlambo says it was where the Deputy Judge President was present. But he says there was no meeting in January with Judge President Mlambo. But Judge President Mlambo recalls it. Now, if we were to really ask the question, is it reasonably possibly true that there is a memory lapse in the recollection of the meetings? It's possible. Because they themselves operated at a level of informality between themselves. No specific dates are given unless you get them from the specific letters or emails that are gotten. Anyway, so that is what
I just want to just put a finger on the last point that you've mentioned. If there's a doubt about the meeting in January, as testified to by Judge Mlambo, and isn't that cleared up? Because he had to appoint judges to take up Judge Makhubele's role, so to speak. And he couldn't have done that later than the middle of January, because Judge Makhubele had to be present at court as far as Judge Mlambo was concerned. As per the roster, I don't know if you follow.
Yes,
the
I do
question
follow.
is, so when Judge Mlambo says that that there was a meeting with Judge Makhubele sometime in the middle of January. That is supported by events that happened outside the meeting because he had to replace her.
Yes.
Yes.
But you know, I think you, with respect, you also must accept that the discussion that she says was reflected in that meeting is not referred to anywhere else. He doesn't record it to the minister's letter. And that is our concern. The concern is not, I'm less concerned about Judge President Mlambo's recollection of the meeting per se. There may well have been a meeting, according to Judge President Mlambo. I'm concerned about the content of what he says was discussed in that meeting. And when you look at that content, and you look at the subsequent events as according to the President's point, you look at how Judge President Mlambo conducted himself after the meeting of a discussion in which he plainly says that we're not okay with this conduct. When he writes the letter to the minister, that's not what he says to the minister. And I'm saying, try and resolve that kind of question. It's a very difficult issue to resolve if you are interested in finding people's credibility. Because that in itself shows that we could ask many questions about why them, and in fact, Advocate Malega did ask those questions, why it was not reflected. And the answer is unsatisfactory. You can't say, in answer to a question, it was unsatisfactory to respect Ms. Levo, because, and as I'll tell you why it was unsatisfactory, because Judge President Mlambo says it was the official reason. What is official about that reason? What is an official reason? There is no official reason there. But I'm not there because I accept entirely that the level at which these two engaged is a level of informality that one could remember things that were not remembered. I mean, it doesn't matter what Judge Makhubele's views were. In fact, Judge Makhubele says there was no meeting, right? The submission I make is that if the meeting of January did discuss that she was refusing to take an oath of office, that's not borne out by the subsequent conduct of the Judge President, who has a duty, as far as is a legal duty, constitutional duty, to report a judge who is refusing to take an oath of office. So we can try and make big issues about this thing. It's not a criminal trial. I mean, people must try and just relax about this level of wanting to be precise where the evidence is not precise. Mlambo does not recall precise dates. Makhubele does not recall precise dates. They may remember conversations that happened. And that is what the tribunal ought to. They must then address the question, is it reasonably possible true that this could have happened? Is it reasonably possible true that, you know, Judge Mlambo would have said to Judge Makhubele, you know, you're misconducting yourself. How can you go to corrupt people coming here and all that, and then not reflect it in the minute to the minister? What would have been the discussion there between the two of them? All I'm saying is, do not be trapped in the idea of trying to find Makhubele guilty of lying as put by the other side. There is a possibility, many possibilities, in the imprecise evidence of Mlambo himself that can tell you. And I want to emphasize the informality of the discussions between the two of them. I'm now going to deal, so in our submission with respect, as a matter of law, there was no, Judge Makhubele was not a judge from the 1st of January. She was a judge from the 1st of June. And we've set out the reasons why she was not a judge during that time, January to June. Much is made about the fact that at some point she went to Mlambo and wanted to reassume her duties on the basis of the 1st of January appointment letter. Well, Can we accept that she was frustrated? Simple. She decided, okay, I'm getting out of these positions. And according to the discussion that was taking place, she was going to be a judge in April, and this was not coming through. The president wasn't signing, and she wanted certainty around it. Is that something that is acceptable? You know, she was just frustrated by the fact that the certainty around the appointment was not coming through. Now, Judge Mlambo was correct in refusing to bring her in, because Judge Mlambo was correct that she was not a judge at the time. Because if she was a judge, that would have been incorrect for Judge Mlambo to refuse to get her to take an oath. So it cuts both ways, that when she in fact acted in accordance with that minute of January, Judge Mlambo specifically refused to have her take an oath of office based on that particular minute, because Judge Mlambo accepted at that time that there was a different process in place which would give certainty as to when she is actually appointed. We've dealt with the test for gross misconduct in our heads of arguments, and we share the same test as the complainants. And the test that has been accepted and is generated from the Canadian jurisprudence is whether sorry, I must just find that test. Yeah, whether the conduct for which she is blamed is so manifestly and totally contrary to the impartiality, integrity, and independence of the judiciary that the confidence of individuals appearing before the judge, of the public in the justice system, would be undermined, rendering the judge incapable of performing the duties of his office. And if you look at that particular question, I mean, is she unable to perform her functions as a judge independently simply because she was not a judge, even accepting, I mean, sorry, she was not a judge between January and June? I mean, can it be said that on our submissions that she was not a judge, that would fall away? And my learned friend, Mrs. Milano, will deal with the part two of how that test would apply. But we've dealt with that test extensively to demonstrate that if you apply that test, you will find that is a matter of law. And here you have to resolve the question of the two appointment questions and refuse my learned friend's invitation to ignore that there are two appointment processes that appear to have taken place of Judge Makhubele. You've got to give an interpretation that makes sense of what the conduct of the president was, precisely because the president speaks through the papers, and the papers tell us that the process of appointing her started when representations were made to him, and he accepted that those representations could be considered by him even after having the appointment a minute before him. He accepted that those representations could be entertained by him. Once the president indicated that he was considering the request for an appointment later than the 1st of January, then you could not in good faith suggest that there was a binding appointment, a valid appointment, beginning on the 1st of January.
Can I just pause there for a minute? We know that there was an appointment for the 1st of January. Is that common cause?
No, sorry, it's correct.
Now, the appointment of the 1st of January, what happened to it?
In a way, the moment Makhubele refused to be appointed on the basis of the 1st of January, that was the end of it. The president had to decide whether to insist on that appointment taking effect or to accept the representations that were being made to him about making the appointment start at a later date.
Now, so the appointment for the 1st of January would be dependent upon whether Judge Makhubele accepted it or
Yes,
not.
yes,
Is that,
yes.
that's what you're saying.
That's what I'm saying.
Now, we know she didn't take the appointment for the 1st of January.
Yes.
When was that conveyed, either to Judge President Lambo or to the relevant authority? On the evidence.
On the evidence, it appears to have been first conveyed to Judge President Lambo on the 4th of December, when Makhubele said to Judge President Lambo that he believes that her appointment should be for April, and that it was in the interest of the bench that that should be so. But as a formality to the president, it was conveyed at the time when the judge president conveyed in a formal communication to the minister the circumstances of Judge Makhubele and her representations.
And that would have been towards the end of
That would have been towards the end of January, yeah. And I think the opinion would also assist when the opinion was taken in and when there were meetings. All that, just the steps that were taken as soon as a formality was triggered.
Let's see if I've got that clear. That as far as Judge Mlambo is concerned, on the 4th of December 2017, it was already clear, as between him and Judge Makhubele, that she could not take up the appointment, or she would
That's
not
correct.
take up the appointment first.
That's
January.
correct.
Then what do you make of his response, well, as they would say in English, or in Afrikaans, that it was a fait accompli, it's too late now?
No, but that's not the only issue that he said. He said, let's meet. I know that it's an interesting point, but he says, it doesn't just say it's a fait accompli, it's done. He says, let's meet.
Then just read this whole response. He says, well, it's your fault. Now, not getting back to me earlier, the president has already made the appointment.
He says the delay is your undoing, unfortunately. The president has already done the appointment with effect from the 1st of January 2018.
Yes.
I am waiting for the appointment letters and certificates. We can meet week after next.
Yes.
Can we just give significance to the fact that there is an invitation to meet?
Now, but what do we say about what goes before that? Unfortunately, the appointment is already
No, that's the judge president. He was conveying a fact
Yes.
that had happened. But there are two facts that have been conveyed.
Yeah.
The first one is an appointment by the president has been made. The second one is that Judge Makhubele was not taking that appointment for the 1st of January. That was clear.
Yes, no, that it was clear from her.
Yeah.
But,
No, I think from everybody.
well, but then why the precursor to we shall meet?
No, because Judge President Lambo has the unenviable position to now manage this transition for Judge Makhubele. Judge Makhubele is making it clear, I'm not taking the appointment on the 1st. I want us to discuss this issue. And he has said, after much reflection and considering every aspect of the challenges, I think that it will be in the best interest of the business. That's what she has said. She said in April, right? So Judge President Mlambo, as he should, then decides that he's going to take administrative steps in order to make that happen. But I accept that from his point of view, the first issue was to try and get her to take the oath of office. When she says no, then to write to the minister to say, we have a problem. But the point of the matter is that the judge president was really trying to manage an appointment that was becoming difficult. And that it was not an appointment that had been accepted by Judge Makhubele is very clear. I will stay with my heads of arguments on the issue of whether the president's power was functus, because I think there is no question about it, and so I will rely entirely on my heads of arguments, which also appear. On our heads of arguments, which also appear in our supplementary bundle. Sorry, in our supplementary submissions. The final point that I want to make, I just want to make just final propositions that I think should be highlights of my submissions. First submission is that, and I'm not going to refer to the evidence, but just the submission is that Judge Makhubele did not accept the appointment of President Zuma of the first, which was in November, in terms of which she would commence her duties on the 1st of January. When her position was made clear, in whatever interactions she had with the Judge President, the administrative formal step that was taken by the Judge President was to convey that position to the minister. So the issue is conveyed to the President. And there was a further administrative steps which were taken by the ministry, which was to obtain a legal opinion in terms of which the question of whether an appointment date could be deferred was considered. That appointment, that opinion said what it says. It's in the papers, and I'm not going to reiterate it. And then the President must have considered Judge President Mlambo's representations, which representations were what he had been told by Judge Makhubele. The President must have considered all the information relevant for the decision to appoint to start in June. And when that appointment was made in June, it was the appointment that was lawful and valid, which was accepted by Makhubele, who immediately took the oath of office and started working as a judge. And I would, as another highlight, I would urge the tribunal to not accept the invitation to call Judge Makhubele a liar. There is no evidence of a lie. There is an evidence of differences of recollection, and I would also urge the tribunal to consider her evidence together with the affidavits that are in the record. Her affidavits in which she explains all these allegations are dealt with in affidavits. And the fact that it's in an affidavit is quite easy. It's also very interesting, important. So you can go to the affidavit and deal and look at what she says in an affidavit and what she says in evidence in chief. I'll then urge the tribunal, in line with this duty, to hold a process that is fair, that advances the interests, the dignity, the independence, and the impartiality of courts and the integrity of the judicial office, to extend to the judges that were involved in testifying against each other the presumption of integrity. And when they do so, they don't readily accept that one was lying and the other wasn't, simply because the evasion was not put to the other. And then, I keep saying finally, but, in addition to what I've just said, I would urge the tribunal to reflect a little bit on the role of the evidence leader, who should at all times remain impartial. And this is where I don't understand why they should have the right to reply. If we are maintaining an impartial, if they're not prosecutors and they're just an impartial evidence leaders, why are they being given the right of reply? To me, or to us. Oh, we haven't gotten there yet. I thought it was referred to in chambers yesterday. No, it was mentioned yesterday in chambers, but I accept that once I've raised it as a formal position, then you can reflect on it a little bit. But I'd like you to reflect on it and see whether or not it accords with the tribunal role to place the evidence leaders in a position where they are, in fact, antagonistic of us.
Well, can we just pause there? Sorry. You have in your opening remarks raised certain, directed certain remarks as far as their conduct was concerned in how they dealt with the matter, haven't you? Yes, you did. And shouldn't they then, and I'm simply asking and what your view is, should they then have an opportunity to say something about that?
No, as far as I said, as I reflected on their conduct,
Yeah.
I think they're entitled to say something about that. What I really want them to know is that I'm not saying that there are certain remarks they made which are bad remarks, and I don't think that I can run away from it. Calling Makhubele a criminal is not right. But I'm saying, as evidence leaders, it is not open to them to say, we want you to find that Makhubele lied because he did not put a version to the other party, or even rely on those principles. And I'm saying, as evidence leaders, it's their duty to be impartial, to even have sought evidence that was supportive of Makhubele, to have even led Makhubele in evidence. Makhubele should not have had to find legal representation on their own. If they were evidence leaders, all they needed to was sit down with her and say, okay, we're going to lead you evidence. This is what statement we can take from you. This is what evidence we're going to lead from you. Because they must maintain an impartiality. I know they are prosecutors and they're not used to being impartial, but but it's important that they maintain a level of impartiality.
And I understand that. It is just, and subject to what you have to say, and I'll confer with the rest of the panel, whether they should be given an opportunity just to deal with the accusation that you...
No, I think that is fair.
Yes.
That is fair, because I think what they are likely to say is we really apologize.
Well,
and we are sorry that we didn't take an impartial position and to the tribunal.
Well,
and that would be very nice.
Yeah,
but
we shall hear from them. I think they're entitled. The question simply is this. I think they're entitled to have something. Maybe they have nothing to say to it. I don't know.
Yes.
Yes.
But on the content of the issues,
No, the outcome.
okay, there is also one thing I must accept. Mr. Pava was correct that in our heads of arguments, we say that Makhubele, when we deal with the issue of her CV, we didn't reflect the evidence correctly. That we accept that criticism. I think the tribunal can take the evidence that's on the record as the evidence that our approach was to just cut out things that we didn't think were necessary and get to the point. The point of the matter is that CV was going to the minister, and that's how we just thought we would cut out most of the things, because for us they were just issues that didn't take the matter any further. Nothing is going to be found in respect of that CV that went to a neighbor, that went to the minister and the appointment. No, there's nothing that turns on it. But we accept that we're not forensically correct in reflecting the evidence we did, and we appreciate that you pointed that out to us. So the panel can take notice of that part of the paragraph. I think it was paragraph 58, and accept that it's not complete, in that it doesn't reflect accurately the evidence that was given by our own client. And she actually pointed that to us when we submitted when we had submitted the heads of argument. She did point that to us. So then, of course, with the second issue would be whether, and I accept that my learned friend for the complainant will have a say on this one. Do they even have a right to be core evidence leaders?
Well, they are not, as far as my understanding, and I'm only speaking for myself, they are complainants and have an interest in the outcome of this tribunal. And it is, as far as that is concerned, they alone best to speak about what their complaint is all about. You're quite correct, they really have nothing to do with the first part of this inquiry. It's the second part. And I don't really know what Mr. Simelane is going to say about it. My understanding is Mr. Simelane will talk to
Yes, yes, definitely.
Yes. And I will then deal with the issue as such.
As they arise.
Whether they should reply or not.
Yes.
As far as your argument
They
is
should,
concerned,
they should keep quiet, yeah.
They're entitled to at least respond to the criticism that.
Yes, no,
Yes.
definitely.
I don't really know what Mr. Simelane is going to say, but I will deal with it when he has spoken, and if there's anything that requires the complainant to say in response, then I will deal with it then. Is there anything further?
The very last issue, I appreciate the time you've given me to make the submissions I've made. We stand by our heads of arguments, and we really urge the tribunal to look at this. And I asked the question earlier on, how do we clean up this situation? Because that's what you're doing, you're cleaning up the situation. So if you have to find Makhubele guilty, of course, you must do it. But if you are not finding her guilty of misconduct, then we would urge that there are certain terms and words that have been paraded here that really make it difficult for her to hold her head up high and be a judge that we expect her to be. Because this terminology used to describe her, criminal, flirting with corruption, they are not terms that ordinarily should be used without, but I'm saying that should never no, but I'm saying, if you find that there is evidence like that, that's your duty to find that evidence and make those remarks. But I'm saying there isn't. And if I'm correct, then I would urge that you say something about those words in your final write-up, so that we start restoring the dignity of the person whose rights have been violated so gravely through a process that was supposed to simply hold her accountable. But now she has to answer to criminal charges and all that. Actually, finally. I will also not deal with the issue of jurisdiction. But just to say, to the extent raised by, and Mr. Simelane will touch on it as he deals with the PFMA and the other allegations of criminality and all that. We are not sitting here to investigate criminality. We are not sitting here to looking at financial misconduct. You are not sitting looking at corruption. You have to look at what the test of gross misconduct says you are looking at. Whether the conduct alleged is such that she cannot exercise judicial power, and there's no public trust in her ability to exercise judicial power impartially, independently, and with the requisite integrity. I thank you for your time. Unless there are any further questions, those are my submissions.
I'd like to, Chairperson, just briefly. You make a request to this tribunal, Mr. Masuku, to go into what is the role of the evidence leader here, inter alia. But can you show me where do I find that in our terms of reference given to us when we were appointed to this matter? Are we to look at the role of the evidence leader? Won't we be acting outside the scope of our appointment as tribunal members if we're going to look into what is the role of the evidence leader? And make a
So
finding?
you'll find that in the Act, I think in the rules to regulate procedures before Judicial Conduct Tribunal. It's in Section 7, 9. The evidence leader may cross-examine any witness called out on behalf of the respondents, re-examine any witnesses called in terms of sub-rule, re-examine witnesses, and it says a lot. It also gives the respondent the right to do exactly the same thing. But they are called evidence leaders for a reason. They are not called prosecutors. So we suggest that and in fact it could improve even just the rules itself in the JSC to reflect a little bit on what exactly the role of, because it would take away the burden on judges who are here to start looking for counsel. And if you have got an impartial evidence leader who is interested in presenting both versions, this is what the complainant says, this is the evidence, this is what the respondent says, and this is the evidence. You lead both of them. And in fact, they say you lead that evidence without giving any, what do they call it, comment. You lead the evidence and you let the tribunal decide on the evidence on both. It feels like, especially when you've given the complainants the right to also lead evidence and to make submissions as we have. Sorry, he's shaking his head, but he asked for that right and you denied him. So what I'm saying is it really just transforms the tribunal into a prosecutorial sort of adversarial system, when in truth, when you're inquiring into fitness, or rather the conduct of a judge, you're engaged in a very sacred process that ought to be held with a bit of reverence. So I'm not saying that that's what they didn't do. I'm just saying if we'd been here right from the beginning, and the Judge Moshidi actually raised it and said, there's no one here who must own us and all that. This is an inquisitorial thing. I'm sure that my sister there will accept immediately what I'm saying wholeheartedly with no reservation, that they could lead both sides of the story and be told through the evidence. They will be okay with that. Those would be our submissions.
Yes, thank you, Advocate Masuku. Well, as they say where we come from, Mr. Simalani, it's lunchtime. And we will then take the lunch adjournment and we'll hear you at 2 o'clock if that suits you. Yes, thank you.
Thank you.
Yes, Mr. Simelane, you on.
Thank you, Justice, and members of the panel. In the past 2 days, you heard a lot about how this matter has progressed to be where it is. The first part of the complaints has been dealt with by my learned senior Masuku. I'm going to be dealing with the many aspects that relate to the PFMA and the conduct attributed to the respondent as a member of the EBOC, the Board of Directors. When I refer to her, I'll refer to her either as, depending on the context, either as the chair or as the director. The first part that I thought I should address you on is the context in which those charges have been formulated with respect to the legislation itself. I think there's two issues, there's two pieces of legislation that apply in this case. The first is the Companies Act. PRASA is an entity. It is a private company whose sole shareholder is the minister. It is governed in terms of the Companies Act as it is amended. So what that means is that once one is appointed on the board of PRASA, like the chairperson, the respondent was, as interim chairperson, she became a director in the normal course like any other director. And as a director, directors' duties are outlined in the Companies Act. There are fiduciary duties, there are responsibilities. And their responsibilities are to the shareholder, primarily, and to the company itself. With respect to the responsibilities to the shareholder, it's for obvious reasons. Shareholders are the ones that invest money in a company. They are the ones who inject capital. And because they inject capital, they have voting rights and they dictate who sits on the board and they influence how the company is run. So anyone who is on the board primarily follows the instructions of the shareholder. That's their boss, that's the mandate giver. And on injection of capital, returns are expected. The fact that PRASA is a state entity is no different, same expectations. So when the respondent was appointed as interim chair, she was effectively appointed as a director and she was designated as a chairperson in the interim. And as soon as she accepted that position, in terms of the Companies Act, she owes her duty to the company and to the shareholder. So with reference to the point made that she didn't want to disappoint the minister, that's the context in which it must be understood. Minister as a shareholder and as an appointing authority and as the provider of the capital to be invested in the business and for the business to invest, and therefore the shareholder needed at all times to be kept comfortable in the manner in which the affairs of the company are being conducted by the directors, and in this case the respondent is one of them. That's one context. With respect to their obligations when they fail to meet them, fiduciary duties kick in that the directors owe a fiduciary duty to the company, and what that means is that they act in the best interest of the company. They don't have a conflict of interest personally in the conduct of the affairs of the business, and they act in good faith. It's been alleged, and I'll deal with it later, that in the settling of the claims, the interim chairperson undermined those fiduciary duties. I'll deal with it later, but those are the fiduciary duties, which attract consequences should they not be met. If there's a contravention of those fiduciary duties, a director can face litigation personally if the company suffers any loss, as the case may be. So when one is appointed in that position, it's important that it is understood that that individual, in this case the respondent, as a director, had to deal with that particular situation. The other context of this particular complaint is the PFMA. I'll also deal with it in detail later, but the PFMA is the Public Finance Management Act, which is basically the legislation dealing with the financial aspects of management of public monies in institutions or departments, as the case may be. And the large part of the attack on the respondent is with respect to the PFMA. So I'll start with the former, with the Companies Act. In the discussion and presentations and evidence led, you would have been taken through and heard expressions about delegations of authority. The point I want to raise about the delegations of authority is that we must be reminded where delegations of authority come from. So in other words, when the directors of a company perform their functions, what is the source of their authority? The source of their authority, in this case, would be the legislation in terms of which PRASA is established, the legal succession to the South African Transport Services Act. That's the legislation. It's a 1989 legislation. It was later amended. And in that legislation, there's an important clause. It was there in the 89 Act, and in the subsequent Act, I think of 2008, it was there. And it's section 24. And it says that, and this is where it gives authority to the board, it says the affairs of the corporation shall be managed by a board of control of not more than, in the first legislation it was 10 members, in the amendment it was 11 members. But the critical part for your consideration is that the affairs of the corporation shall be managed by a board of control, which means the power and the authority to run PRASA lies with the board, and only with the board. So what did the
You submit that, knowing that at that time the board of Judge Makhubele did not have their own delegation of authority. The evidence before us is that it was operating under the previous board's delegation of authority. Are we together?
Maybe together, that point, Justice Moshiri, I'll deal with. It's not something you should concern yourself about. At this point in time, no, understand, I'll deal with it. At this point in time, the issue is about where the authority comes from, because a large part of the dispute raised here is a contest for influence within PRASA between, in this case, the respondent and various officials, the three officials the two officials at least that were mentioned here. And I'll explain the context of why, when you look at it, you should look at it in the proper context. I've indicated section 24. It's the same in the amended legislation. What the delegations of authority do, it's the board giving its power, delegating its power to the officials. There are various officials to whom the delegations are given, including Ms. Ngoye, including the acting group CEO, Zide, and a number of other officials. The delegations are common cause, and I don't want to waste too much time on them. To the extent necessary, I'll take you to the specific ones. So when they exercise their delegations, it is tried that the delegator does not give up the power, doesn't lose the power. So in other words, it's conceivable that the delegator and the delegatee can exercise the power at the same time. It's not an issue that is not understood in the sector in which it is applied. So in this case, therefore, if it is clear that the framework is that the board and the directors run the company and they've delegated some of their authority, those to whom the delegations are given can run those aspects delegated to them. But it doesn't take away the authority of the board to also act on exactly the same issues. That is the context that I've set up. That is the context in which I'd like these issues to be understood and considered going forward. Now, the charge of non-compliance with the PFMA, well, all of the charges that relate to non-compliance with the PFMA relate to the board itself, for the simple reason that the board is the accounting authority for PRASA. The board is the accounting authority for PRASA. It is not the respondent. Section 49 of the PFMA tells us, it says the following at 49.1. Every public entity must have an authority which must be accountable for the purposes of the Act. Then it says at 49.2, if the public entity has a board or other controlling body, that board or controlling body is the accounting authority for the entity. What this means is that in this case, the board of PRASA, from the chair and all the other members of the board, account for everything that PRASA does. Account for expenditure, and as I indicated in terms of the succession legislation, account for the management of the institution, all of its affairs, assisted by those to whom they have delegated the powers. If there's non-compliance with the PFMA provisions, what happens? There's a framework in terms of which the specific conduct is investigated. I'll take you through that framework briefly. That framework provides for each alleged conduct to be investigated, each alleged conduct investigated, evidence-led, and the report and findings made in relation to the accounting authority responsibilities to fruitless and wasteful expenditure, as the case is in this case. In this case, you know that it is the respondent that is alleged and is charged with fruitless and wasteful expenditure, and the respondent is referred to as the accounting authority. I've indicated that the respondent is not the accounting authority of PRASA, but the board. So when that happens, findings are then made as to what action, consequence management action must be taken once it's been established that an accounting authority has been in breach. Which means we go to the point raised in our heads of argument about whether or not this tribunal has jurisdiction on this particular matter. And we submit that it doesn't have jurisdiction. It does not have jurisdiction for reasons already covered in the first part of the charge, which is that the conduct involved in the second charge does not relate to judicial conduct. It was not conduct that occurred in an instance where there was judicial activity, and that argument has been led. But secondly, the framework in terms of which the alleged conduct is to be investigated is not for this tribunal to go through. It's not for this tribunal to investigate those matters. It's not for this tribunal to make findings on those matters. It's not for this tribunal that has the authority in terms of the PFMA to conduct that investigation and produce those particular outcomes. And the fact that we're here, we submit, is it's a function of a misunderstanding or misconception of the application of the PFMA in relation to the issues so raised. It was raised with respect to the first charge that because of the conduct I've described, the code of ethics for judges doesn't apply, and the JC doesn't find expression here. So which means the only area in which jurisdiction can possibly be found, which we submit it doesn't and is not found, is with respect to section 177.1 of the Constitution. And 177.1 of the Constitution talks to a judge who may be removed from office if the JSC finds that the judge concerned suffers from incapacity, is grossly incompetent, or is guilty of gross misconduct. Incompetence, incapacity, or gross misconduct in this particular case in relation to Justice Makhubele doesn't apply because the respondent at the time was a director of a company performing functions in terms of the Companies Act, therefore had a responsibility to demonstrate loyalty to that particular company by acting in its best interest, and must have had fidelity and demonstrated fidelity to the shareholder as the investor. That's on the one part. On the part relating to the PFMA charges, the accounting authority is the board and not the respondent. Fruitless and wasteful expenditure, and in this case, the fruitless and wasteful expenditure relates to not the actual amounts that were settled in the claims of about 50 million or slightly more. The fruitless and wasteful expenditure, as I understood the submissions correctly, is that it is the money that was spent by PRASA in the litigation to recover those. The framework for fruitless and wasteful expenditure I'll provide a copy, President Yapi, of the framework, but it is a public document. It's a National Treasury document titled Fruitless and Wasteful Expenditure Framework, and it is a document which must be followed by all public entities and departments in investigating fruitless and wasteful expenditure. And at page 8 thereof, when it deals with an investigation, it requires, clause 17 of it, that the accounting officer or the accounting authority must conduct an investigation if it is suspected that there is a possibility of fraudulent, corrupt, or other criminal conduct emanating from the incurrence of fruitless and wasteful expenditure. Clause 18 of it says, the accounting officer or accounting authority must, upon suspicion of a fraudulent, corrupt, or other criminal conduct, refer the fruitless and wasteful expenditure matter to a function performing investigations in order to establish the facts about the transaction and to obtain recommendations on the next steps to be taken. And the third relevant one, 19, the investigation must provide the accounting officer or accounting authority with at least the following information. A, root causes that led to the fruitless and wasteful expenditure. B, employees responsible for incurring the fruitless and wasteful expenditure. C, fraudulent, corrupt, or other criminal conduct. C, whether the matter was referred to the South African Police Service. And E, any breakdown in the designed internal controls and the impacts thereof. And it says at paragraph 20, the investigation referred to above in paragraph 17 must commence within 30 days after the determination test. So the question is, has that been done? Has that been done by the relevant accounting authority? In other words, has the PRASA board, whether the present one or any PRASA board after the board in which Justice Makhubele was chair, has it done that and followed the framework that is given? There is no evidence that's been submitted before you that that was done, because if it had been done, which ought to have been done, what would have happened is that as part of your bundle, you would have been presented with a report outlining all of that work and identifying for you those members of the accounting authority, in other words, the members of the board, who would have been culpable for the conduct alleged. So in other words, if you have before you, if you have had before you such a report, and the respondent was mentioned in that report, then you'd have jurisdiction to do what you are doing now. But because that wasn't done and hasn't been done, you can't proceed and do what you are doing now because you don't have all of the information before you. What you have is evidence of officials of PRASA who have something to say about what happened at PRASA in respect of the conduct consent, and they have their views. They're entitled to those views, simply because they're not just officials, but they were senior officials with delegations of authority to do work, including settle claims themselves, the claims consent, and they had something to say about it, which they did say. We have evidence of the attorney, Mr. Mokhashwa, who also gave his views. But what you need, that you don't have, because it's not your job to do that work, and the work that's supposed to be done was not done. What you do not have is the evidence of the accounting authority, other members of the accounting authority, other board members. You only have the evidence of one. You don't have the evidence of the others, the 5 or 6 others at the time who sat on that board, because that investigation was not done. You don't have the evidence of Mr. Zide, who's referred to in the documents, who was the acting group CEO, who had his own delegations of authority from the accounting authority, which delegations gave him the power to run the institution. Mr. Tintswalo, Ms. Zide, sorry, Mr. Tintswalo, Ms. Ngoye, were executives whose line of reporting led to Mr. Zide, not the board, not the accounting authority, and more importantly, not the respondent. Their line of reporting went as far as Mr. Zide. You don't have the evidence of Mr. Zide and the members of the board because of the reasons I've just described. So what you're being asked to do in this forum is that you step into the shoes of the accounting authority, which would be tasked with conducting this investigation, to establish if for each of the conduct alleged, the identification of the culpable individuals. You are being asked to step into the shoes of the investigation referred to in the framework for fruitless and wasteful expenditure. We submit you should not accede to that invitation to do that work. And in any event, even if you did, we submit that that would be unlawful. You do not have that jurisdiction. You do not have that jurisdiction, and therefore you cannot do that. We submit that the matter ideally should end there. The matter ideally should end there. There's been an incorrect identification of the accounting authority. It is said it is the respondent. I've read to you the PFMA. It is not the respondent. It is a board. I've indicated that the investigation that is required to be conducted to determine whether or not indeed there's fruitless and wasteful expenditure has not been done. So more than half of the real story, nobody knows yet. There is just innuendo, there is suggestions, there are allegations. All of that are not a problem, provided they're going to be thoroughly investigated and the root cause identified. They're a problem when they are used to then place charges, then make findings, attracting consequences for somebody who is not responsible for those allegations. There's also an important reason why the investigation must first be thoroughly conducted and findings made, because findings give different directions. One is that fruitless and wasteful expenditure can be condoned. In other words, there can be a legitimate explanation on what happened. And secondly, there could be consequences where the issues are referred to the relevant authorities, the Hawks, the police, the SIU, the public protector, as the case may be. Each of those institutions would do their own investigation in terms of their framework, legal framework, and produce their own results with their own outcomes. So it is important to go through that thorough process for that reason. What we have here instead is an unfortunate situation where somebody has been, in the respondent, has been incorrectly identified, incorrectly blamed, and we are now being asked to make a finding of guilt. We submit that the cart has been put in front of the horse, and this matter should be taken out of this forum and be taken to an appropriate forum. As a matter of fact, a check on the SIU website, and you can take judicial notice of this, I submit, will tell you that there is an SIU proclamation, Proclamation 43 of 2024, which proclamation is for the SIU to investigate all matters of PRASA, starting for the period 2010 to 2024. It's a huge mandate, and those investigations are currently underway. In other words, the investigation into the very same issues that you've been asked to consider is underway. The respondent is one of those, by virtue of having been a chairperson at the relevant time. Is one of those who would be investigated and whose conduct that is here would be investigated, and ultimately the outcomes would be pronounced. That is why this forum should not be looking into this matter, amongst other reasons that I've described. Now, on the specific acts themselves that are alleged, it's been alleged that the respondent only focused on the CIA matter, or the CIA claims. Advocate Masubu indicated why it's unfortunate that that charge has been framed in that way. First of all, a director of a company with the authority to run the affairs of the institution is entitled, where the board deems it necessary, that certain aspects of the business of the organization be looked into by a board member. It's not uncommon that non-executive directors take charge of a specific issue. At least we know it's not unlawful in terms of the Companies Act. It's not unlawful. At the relevant time, PRASA was reported on in the media for a variety of reasons, many of which were unpleasant because it was about a number of transactions that that institution was involved in. All of that led to some of the officials of PRASA, including the respondent, appearing before the Zondo Commission later, the State of Capture Commission later. So what you're being asked to do is make a finding that in focusing on the CIA claims, the respondent acted incorrectly. She didn't break the law, we submit. There's no investigation that she broke the law. There was nothing wrong in focusing on the CIA matters if it was identified that there was a need to do so. In this case, when approached by reporters to settle these claims, the respondent looked into the issues, identified the issues, and acting in the best interest of the company, considered them with Zide as the group CEO, and having discussed or reported on these issues at board, went ahead and settled the matter. The investigation that I referred to earlier will identify whether or not in doing so there would have been anything unlawful in terms of the PFMA or any other law. Now, in terms of the PFMA, there's nothing wrong with that because it is the day-to-day affairs of the institution that she was part of managing in the context of that particular transaction. And more importantly, she did so together with the group CEO, about whom not enough is said when it should, because that is the person who was tasked with the day-to-day running of the institution and managing the staff, and to the extent necessary, giving feedback to the board. So in giving feedback to staff, the group CEO would and should have ensured that staff are kept up to date, not necessarily make them happy. It's not his job to make them happy. That's how the hierarchy of an institution works. You don't have to make your staff happy if decisions are being taken at an appropriate level. In this case, the engagements with respect to the settlement claims were being made at the right level, at group CEO level in terms of discussing with the chair, and at the board level in terms of the interim chair being involved in those discussions and finding solutions. The merits as to whether or not it should have happened, it should not have happened, I submit with respect that this is not the forum at which that kind of issue should be brought to bear. Why? Because it is subject of an investigation, and that investigation must be finalized. Even if it was not subject to an investigation, you would first need to be told what is wrong with it, what is unlawful about it. You won't find it anyway because it's not unlawful. It is not unlawful. And in the context of settlement claims, and the settlement claims and the settlement agreements that are concluded on a daily basis, and more often than not, if not almost all of them, they are settled on a no-fault basis. No-fault basis for the simple reason that parties, both sides, look at their own personal challenges with respect to the business they have to run. PRASA, then and now, is in the business of doing important public work. In the scheme of all of the work that it has to do, management is entitled to take decisions about what to spend its time on. At the time, and the relevant time, such consideration was placed on these settlement claims. There's evidence of the respondent indicating that the claims were looked at. At the time, she thought the concessions that were made were serious, and they placed the company at a disadvantage, and having regards to those concessions. And in order to move forward as an institution, these are the kind of claims that the settlement of which was possible. That's the context of how those settlement claims were arrived at. And the involvement of Mr. Zide as the group CEO was to provide to the chair important information from the company about those claims. Whether he did that in the manner expected or in the manner alleged, maybe it should have happened, is a different story. And that on its own would be subject of another investigation to assess whether or not he acted incorrectly. Now, the settling of those claims was done, was finalized, and yes, there were actions later after the sheriff processes to get back those monies. But at all material times, when those claims were entertained, there's no evidence that it's been led, that the respondent did that work for personal benefit. There's no such evidence. And there is no evidence that she had any untoward intent towards that. And yesterday, on behalf of the complainant, it was indicated that there's no allegation being made that the respondent was corrupt in any way, because in truth, she really wasn't. So to the extent that there is an attack on the fact that there was a settlement, on the charge, we submit that it is not the respondent who must answer to the charge. It is the accounting authority as a whole. It is the board. To another charge that the legal unit of PRASA was marginalized. We submit that they were not marginalized. If they were marginalized, we submit they were not marginalized. But to the extent that it is argued that they were not marginalized by the respondent. They would have been marginalized by their direct reporting line. The group acting CEO whom Ms. Ngoye approached to express displeasure at the fact that they are being kept out of the loop, as it were, for want of a better expression, in what was being discussed. At the relevant point, ought and should have raised with them and given the necessary explanations as their manager that the matter was being attended to by the board and that's why it should be resolved. There's nothing unlawful there. Ms. Ngoye and Mr. Tintswalo are entitled to be unhappy about not being kept in the loop. But the responsibility for running and handling that process on behalf of management and on behalf of the executive committee of management was Mr. Zidis. That is where, if at all, any marginalization occurred, took place. It wasn't the respondent. The charge is incorrectly put to the respondent. We submit because of a lack of proper appreciation about how the framework would work.
Mr. Simelane, sorry, I'm not going to even apologize. I'm not going to wait for you to finish. This is inquisitorial, and I'm doing that right now. You can't tell me to wait until the end. Are you saying that we must make a finding and we must ignore the emails that we have seen emanating from Judge Makhubele to the staff or the financial department, putting pressure for the payments to be made? We should ignore all of that. And complaining to voters that are the delay and tell people to settle this matter, not the matter, the payments, attend to the payments. We must just ignore that completely. Not even an attempt to violate the PFMA. I shall stop there for the time.
No, by all means, Justice Mashida, by all means. You say stop even an attempt to violate the PFMA.
What attempt? I mean, that pressure that was put.
No, understand. No, understand. Understand.
Claims.
Now understand how
I see it in that
you
context.
characterize, indeed, Justice Mashida, understand how you characterize that activity. You characterize it as pressure. You characterize it as an attempt to violate. I'll start with the second one. It cannot be an attempt to violate. It either there was a violation or there was no violation. The PFMA charge, if indeed there were to be such a charge, it is a charge that would say the accounting authority is responsible for that. We submit that's not the case here. The respondent, having settled or contributed to the settling of the claims together with ZD, in other words, the management of PRASA, even with some unwilling members, having done that, and the board being informed that there was such activity and there was such claims, it would be up to the board, if it was uncomfortable and unhappy with that work, to take the appropriate action of investigating the respondent alone, because as the accounting authority, the board would investigate one of their own for that, if they're unhappy with it, and take the necessary consequences going forward. It is the duty of that board to do that. And if the board were at one, which it was with the respondent on this, the board would suffer consequences of an investigation, which I submitted earlier, ought to be the kind of investigation taking place, not with respect to this particular forum. Now, the communication and the emails to finance to make a payment, again, these are normal engagements in an organization where an assessment of risk is made that if a matter has been settled, there are creditors who are now owed as a result of either settlement or any other business. Staff must do the necessary and process the work that has been submitted to them. That's normal in any organization. You pay creditors within 30 days if you're owing people. You pay creditors within a reasonable time frame if there's an engagement on an invoice or any other matter. But you do what you are legally bound to do based on the information before you. We submit with respect that this forum cannot characterize that as pressure. Because at the time, there was already settlements reached. Whether or not one was happy with, like Mr. Tintswalo and Ms. Ngoya, about those particular settlements, but the settlements were there and they needed to be paid. So if the respondent then engaged with finance with a view to having those settlement agreements given effect to, and giving effect to by payment, it was not unlawful, it was not improper, it was not incorrect for the respondents to communicate to finance that that is what had happened and that must be done. We can question whether or not it should not have just been Mr. Zide doing it or any other person. I understand your concern, Justice Moshidi, to be that, but why was it necessary that the respondent do that? We submit that it did not have happened, but as a director in a company, having been seized with that particular matter, the respondent was entitled to follow through and make sure that that aspect of the business was closed and that that matter was gone, to avoid any other risk that may arise with those claims not being paid after the settlement. So it wasn't, with respect, Justice Moshidi, pressure. But I'd like to take it further to say, let's say it was pressure. Let's say it was pressure. Would it be so unreasonable that it can be elevated to gross misconduct, to incapacity, or any other? We submit not. We submit not. And that in an environment of that nature, a pressured environment and the external environment would contribute to the kind of pressure that would be in that area, in that space, such that the chair would be entitled on behalf of the board to take the actions that you took and report thereon. But to the extent that a suggestion is made that that was part or indicative of any unlawful or potentially or possibly unlawful conduct or conduct that undermines fiduciary duties, as the case may be, an investigation for that purpose must be done by an appropriate body and appropriate authority and arrive at a particular and proper conclusion. This forum is not there for that purpose, because what you need to do to get to that point is receive the evidence of those that are in the best position to comment further, as I indicated, the rest of the members of the board, the rest of the officials of PRASA who did not have an opportunity to make these presentations. But the evidence as presented is unfortunate that it leads to that kind of view. That's not the picture you should see. The picture you should see is the picture I started with, the context of a board that is intent on running the business of the institution as best as it could under the circumstances.
Well, it appears to be more than pressure, actually, because the person was giving the instructions for the payment to be effected. He eventually gave instructions to the sheriff of the court to go and touch process money. More than just pressure. Sheriff of the court went there, he took the monies. And you still say there was no pressure, there was no urgent instructions given for the court order to be executed. In any event, I hear what you say. Let me go to the other submission that you make, and that is that the finding we can make, because of your point of us not having jurisdiction to entertain this aspect of the complaint, we must make a finding that yes, as a tribunal, the matter came before us, it involved the PFMA. Sorry, our finding is that we have no jurisdiction, we can't pronounce in the matter, and send the finding back to the JSC. Is that the general terms of your submission? That's the kind of finding we can make, because we lack the jurisdiction to deal with this matter.
It's a legal issue, Justice Moshidi. it's a legal issue, and that is whether or not you have the legal competence to engage in this work. It's a fair question to ask, and it's a fair question for you to consider whether you can take action. And to take action, I've indicated already that you'd have to locate yourself in section 1771 of the Constitution. And we submit you cannot be located there, because this conduct, which took place in a different environment, is subject to investigation, by the appropriate authorities. You can say that you don't have jurisdiction, but you can comment that the matter be referred to appropriate authorities. You can opine about where the matter ought to be and ought to be dealt with, but that you can give attention to those aspects of it that don't fall within your jurisdiction, and you make a finding about that. We submit with respect that you cannot do that.
Well, you mean we should make that kind of finding whether or not the alleged perpetrator was a recommended judge for appointment or a judge already. I know on your version she was not a judge at the time.
Yes.
But you mean despite that she was becoming a judge eminently, or she was already a judge? We should ignore that completely and make the finding that you seek us to make.
Yes, I'm trying to understand your question with a view to trying to assist as well in terms of finding out on what authority or basis legally would you make a finding of the nature you are suggesting you could make in these kind of circumstances. Yes, there's a challenge that on our version we're clear that it doesn't apply because she wasn't a judge. But because the conduct went over to 2018 when, on behalf of the evidence leaders and the complainant, it's alleged she was a judge, you may be tempted in looking at it that way to say, under these circumstances, maybe 1771 does apply. We submit that you should not look at it that way, because we submit that our version is correct, is the one that should be accepted, and you would not have jurisdiction. Difficult as it may be to do, it's the right thing to do, and it's a proper thing to do, and a constitutional thing to do. And there is no alleged perpetrator, in my respectful submission in this case, Justice Moshidi. The reference, and I've just been guided, of the sheriff is that, unless I missed it, and I'd be grateful if you can assist me locate it, is that the sheriff acted in the normal course of sheriff's work, and that the attachment of the account was in the normal course pursuant to the settlement of those claims, and that the respondent did not just assist the sheriff, but give an instruction to the sheriff to go and do that. So with that, it can be understood and be accepted that the sheriff just did what sheriffs do when points have reached that particular situation, and the sheriff then went ahead accordingly, but not at the instruction of the respondent.
Oh, well, then we may differ about the procedure, but many years in practice, I don't know unless the law has changed. Once you get a judgment and you get a warrant of execution, you instruct Minister of the Court or the Sheriff. They just don't say, oh, next week we've got this warrant we got last month against Prasa. We'll see to it when the 10th comes. But attorneys will normally write to the Sheriff and say, we want the money, go and attach and remove, we have an auction or whatever. must have been somebody pressing behind the sheriff to execute here.
Yes, there must have been. No, indeed. Even then, it wouldn't be the PRASA attorneys would have given such an instruction. Certainly, CIA would. Oh, absolutely. The plaintiff attorneys would definitely do that. That's the entitlement. It's just that if I thought I heard you, Justice Musidi, indicating that it was the respondent who instructed the. Yes, that's the point.
Maybe I made a mistake.
Oh, no, I understand. Yeah, no, you did say the respondent.
To be
no, I understand
corrected.
that. Yeah, no, indeed. I understand that. Yes, ma'am.
Thank you. Proceed with you. Unless
I've dealt with the charge that PRASA legal unit was marginalized. We submit that it wasn't marginalized. On the charge that there's a termination of the mandate of the attorneys, I think on behalf of the complainant, it was indicated yesterday that that's not the charge, so I will not deal with that. Suffice to remind the panel that when the board was seized with the findings of the Auditor General regarding procurement processes, including the appointment of the panel, it was the board that took a decision that the panel content be suspended and that any legal work be procured via the normal supply chain, in the sense that if there's a legal matter that needed to be heard and dealt with, management approached that by way of a supply chain process procedure, which Mr. Tintswalo and others at PRASA were uncomfortable with because of the administrative nightmare and the agency sometimes with which legal matters needs to be dealt with. I think he gave those concerns when hearing that the board has taken this decision. But the board decision was based legitimately on a finding of the Auditor General that there were problems in the manner in which the panel was initially put together. And we submit that in respect of that, again, if indeed there were to be an investigation as to whether or not that board decision was appropriate or not, we submit that it is the accounting authority that must account for that, not the respondent as an individual, as a loan director, because the board is the one that took that decision. And that's how that matter should be dealt with. The engagement with Advocate Botes must be taken in the context I've described earlier, in that the conversation was first started by Advocate Botes, and it continued, and one would imagine that he must have concluded that dealing with the matter at the higher level as opposed to lower level in the organization, the matter would gain some attention that will lead to its closure. Now, having done that, the question would be, does that conduct by the respondent elevate the issues to fall within gross misconduct, incompetence, or incapacity, as the case may be? We submit that it doesn't. And it doesn't because in the scheme of the line of authority for PRASA, the respondent was entitled to engage in those negotiations, in those engagements, and do so consulting with the relevant authority in management up to until those claims were finalized, which was done. That conduct doesn't amount to gross incompetence, negligence of the type envisaged in section 177(1). If there is a concern about that particular conduct in terms of the framework for fruitless and wasteful expenditure, must be properly investigated by an appropriate body, where all of the evidence would be led to that effect. That also applies to the charge that the respondent entered into a confidential settlement agreement with the parties concerned, and it's alleged that it's prejudicial to PRASA. I think the issue there is about the confidentiality clause. We submit that the confidentiality clause you would find in any settlement agreement, and it is to protect the parties in the settlement against any one of them or any third party accessing the information they shouldn't access, and that there's nothing untoward with the confidentiality clause in that respect. But if indeed there are questions raised about the manner in which those settlement agreements were concluded, about whether or not they're really truly beneficial to PRASA, as a former director of the business, the avenues available in terms of the Companies Act, and with the PFMA, the avenues available in terms of the current board conducting an investigation, or any other institution tasked with conducting an investigation to do. They can do that, produce a report, and then come back and appropriate action taken accordingly. Similarly, with the charge that the respondent frustrated PRASA's attempts to resist the enforcement of the settlement. In the scheme I described earlier, President Yabi and Justice Moshid and Ms. Silevu, if you look at it in its proper context, you would have to say that this board, in the manner in which it dealt with the issues, specifically this one, there may be others, this board acted so out of kilter, so recklessly, that it contravened the Companies Act. When looking at that, even if you feel very strongly about that you can call them all perpetrators, you would have to say, if you were to take action, does it fall within your scope of authority? Would you be able to do that? With respect to the respondent, we submit not. But would another party say, in terms of the Companies Act, you are liable, there were losses incurred as a result of your conduct, you should pay? Of course they'll be open to a damages claim. Of course they would be. But not in this forum. Strong as or passionate as the complainants may be about the conduct, yours is simply to answer the question, is this conduct falling within Section 1771 of the Constitution? Is it ours to deal with? We submit it is not yours to deal with. It is for somebody else to deal with. Not that it will never be dealt with by this forum, but should, after an investigation, a report come back that places you correctly within Section 1771 of the Constitution, then at that stage, and at that stage only, you would have the necessary jurisdiction. But with respect, not now.
Well, can I just interrupt here? When you say the inquiry should go, and we should look at what the board did, we don't have the minutes where the board took a decision that these claims should be settled. All we really have is the evidence of Judge Makhubele. Do you follow what I'm saying? You say we should look in terms of the PMFA towards the board. Where will we find what the board decided?
The issue, Justice Yapi, is this question. Who is responsible to account for the conduct alleged in these proceedings? Who is responsible to account? The PFMA tells us who's responsible to account. The PFMA says it is the accounting authority that must account for this. And it goes, section 50, 51, 52, 53, 54 of the PFMA says it is the accounting authority that must explain itself and account, not one individual. The respondent is part of the accounting authority. But what must first happen is that in terms of the framework, the National Treasury framework, the board of PRASA must take all these facts that are alleged here, which I'm sure it already has, conduct an investigation first and reach whatever conclusion where the investigation takes it. It is, this forum won't get those minutes until that investigation is done, because this forum is not the one where those minutes at this particular point of the processes can be correctly placed. The reason is because the respondent in an investigation by a PRASA board or another authority still has an opportunity to make representations and explain herself together with other board members. The point is that at this stage, this forum just simply doesn't have that investigative mandate. It just simply doesn't have it because it hasn't come here. Now, what could have happened if there was opportunity and there was time, it's possible that any information that it's alleged would have been in a position to assist this particular process. The info could have come from the evidence leaders who would have heard of it, looked for it, found it, and used whatever investigative tools that these processes give the investigative leaders to do, and then that would have been produced. The elementary mistake that has been made here is that the respondent has been substituted for the board as the accountant. That's the fundamental mistake that has led to this unfortunate circumstance. And we submit that this panel must recognize that, and this panel must make an appropriate decision that it doesn't have jurisdiction, and the issues move on. The fortunate thing is that this issue that has been raised doesn't necessarily die, so it's not a matter that's not going to be attended to. It is currently being attended to. It is currently being attended to, and it will reach a stage of finality. And that stage of finality may bring us back to where we are. It can bring us back here. The question is when. And that is difficult to predict because we don't know how the investigation would go.
If I may just then encapsulate what you have to say. The inquiry on the second matter, because that's what we're busy with.
Yes.
You say right now that is premature, that we are sitting here prematurely, that what should have happened as far as the second matter is concerned, I don't understand it being relating to the first matter. We've had Mr. Masuku's submissions in that regard. But your submission is we should wait for an inquiry into what happened, an inquiry being conducted into the affairs of the board and why the board, you say, have taken the decision to settle the claims. Is that what it is that you're saying? Or does we simply as a conduct committee looking at the conduct of Judge Makhubele in this whole issue, you say we are not in a position to come to a conclusion on that issue which is before us until this part of the inquiry into the conduct of the board has been concluded, whichever way, in terms of the PMFA. Is that what you say?
Indeed
if not,
so.
Please correct me.
Indeed so, President Yapi. It would have been different if the following had been in existence. If it had been presented to you that upon settlement of the claims, the board had a problem with it, and the board reprimanded or took action against the respondent, then the matter, that aspect, would be correctly before you. because at least there would have been a process of assessing the conduct of the respondent and the finding made by an appropriate body for it. And then your jurisdiction would kick in under those circumstances. The difficulty we have here is that that hasn't even happened. And the PFMA processes and the National Treasury Framework processes are legislated processes, are mandated processes that can't be avoided. They can't be avoided. So the matter was prematurely brought before you, and we understand how it could have found itself here prematurely, because the complainants just did that. And strictly speaking, an ideal situation is that the matter would have or should have been handled at JCC stage, and not be brought here for you to be able to deal with it on that particular basis. That's the crux of what you're saying. Because if we did it any other way, just other than lack of jurisdiction issue, let's say you make a finding, you find somehow that you have jurisdiction, you make a finding against Justice Makhubele. At the end of the year, early next year, in the scheme of the financial years of these institutions being the end of March, a report is produced which exonerates her because she's made an explanation. Then we have a bigger problem. So it is better to take this medicine now and allow a process that ought to be in play to run its course. And in any event, those processes, as I've indicated, with the SIU are already in play. There could very well be others. If the current board of PRASA hadn't done so, it could actually, after this process start now, finish it within a short space of time, and we're back here again. So we really are in the hands of the legislative framework. But you would only have jurisdiction in terms of Section 1771 if there is a concluded external process that makes a finding, a negative finding against the respondent. Definitely not before then. Not before then. And only because of the nature of the charges. It's the PFMA charges. Justice, I'm at the end of my presentation, if I may confer with my learned senior. President Gabi, may we please have a short adjournment, just so that I can take proper instructions. Thank you.
Ready? We'll stand down for 10 minutes.
We'll do that.
So I don't think there's any need to hear you any further.
President Japia, I did have a few issues that I wanted to respond to that were novel issues raised. If I might just briefly finish, just to be to the assistance to the tribunal and to the extent it's not dealt with by the evidence leader, I'll need about 5 minutes. But I'm in the tribunal's hands. It's up to the tribunal. I'm not asserting a right to reply, but I do have some submissions I think might be helpful if the tribunal wishes to hear them.
I think let's just deal with what Advocate Harrison has to say. Yeah.
Thank you, Chair. In regards to the allegations that were, I wouldn't say allegations, but comments that was made in regards to the evidence leader, I do have something to say in regards to these aspects that were raised. Chair, if one looks into if one looks into the JSC Act and regarding the parts that deal with the hearing of a tribunal, I would like to take the tribunal to firstly to it's page 322 of the instrumental of the books, the Judicial Regulatory Instruments, and under paragraph 7 there, it states as follows: the evidence leader may, at the hearing before any evidence is adduced, address the tribunal without comment for the purpose of explaining the allegations against the respondent and what evidence he or she intends in adducing in support of these allegations. I just want to start with that one off, Chair. And I want to remind this tribunal that in November 2022, we had a pre-trial conference with the Respondents' Council at that time. And we set out exactly what issues we would be, issues or evidence that we would be leading at this tribunal. And we were requested, I would call it in inverted commas, further particulars, for lack of a better word, and we responded to same. And at that pre-trial conference, we were then, there were certain issues or certain things that we also requested from the Respondents' Council to provide us with, like the list of witnesses that are going to be called and documents that should be used. However, there was none such forthcoming to the evidence leader, but be as it may, we continued with the work that we had to do. Further than that, Chair, it also says the evidence leader may then examine the witnesses which he or she intends to call to prove, underline, to prove that the respondent is suffering from an incapacity, is grossly incompetent, or is guilty of gross misconduct, and may adduce such evidence as may be admissible. So that's 7.2 on its own is indicative that the evidence that we are going to lead must be able to prove the allegation that is there regarding the conduct of the respondents. Then it further goes on in paragraph 5. It says the respondent may examine the witnesses which he or she intends to call to refute the allegations against him or her and may adduce such other evidence as may be admissible. So again, the rules are indicating that, or indicative that the Judge Makhubele or the respondent could have produced this evidence. And I say this, Chair, because during the tribunal, if you will remember, while we were conducting the tribunal, and at one stage where we had to, where we adjourned, the evidence leaders were requested that can they kindly obtain the employment contracts for Ms. Ngoye and Mr. Tintswalo, of which we did. We obtained the contracts and they were handed over to the Respondents' Council. So it's not like there was nothing that we had been requested for that we did not hand over as the evidence leaders. Then, to further show what the evidence leader can do, or yes, what the evidence leaders can do, if you look again under paragraph 7.13b, can I just contextualize it so that it provides meaning? Let's start with A. 13A says, after all the evidence has been adduced, the evidence leader may address the court and thereafter the respondent may address the court. B, the evidence leader may reply on any matter of law or fact raised by the respondent in his or her address, meaning that at this stage we are able to respond to anything that we believe that we need to respond to, and have that liberty, because the rules for the for this judicial conduct allows us to do that. Then, just on an aspect that was raised in regards to the criminal issues, or the issues that were raised in regards to us raising criminality, I want to point the tribunal, to Section 32 of the JSC Act, and it says, evidence disclosing offense. If the tribunal is of the opinion that evidence before the tribunal discloses the commission of an offense by the respondent, the tribunal president must notify the National Director of Public Prosecutions accordingly during or after the hearing, and cause a copy of the record or the relevant part of the record in question to be submitted to the National Director of Public Prosecutions. So on those bases, this is the reason why we had laid the evidence, because there was a feeling that it may be sufficient. We are not saying she's guilty. We are saying if there is evidence to suggest same. So on those bases, Chairperson, this is the reason, the instruments set out what the evidence leader can do. And as a result thereof, we believe that we did or conducted ourselves in the manner in which we should have conducted ourselves. I don't know if there's anything further, Chairperson.
No, there's nothing further.
Thank you.
I think Judge Mshidi has a question.
May I, Mr. Bishop, may I revisit one aspect that you dealt with yesterday afternoon here in addressing us, and that, I think, led to the comments made by Mr. Masuku this morning about the language words that were used here, which were not fit to be used against Judge Makhubele as a judge. I hope you recall yesterday afternoon, in the process of addressing us, you used the word that Judge Makhubele refused to commence her duties on the 1st of January 2018. I may be wrong, but I thought I heard you say she refused. And if that is so, I just want to know what the basis of that is, because then his complaint this morning to us may be correct.
Thank you, Judge Mshidi. I did use the word refused, or words to that effect.
You did?
Yes, and I stand by it, Judge Mshidi. I didn't understand that to be Mr. Masuku's particular complaint. I think his complaint was about particularly paragraph 314 of the complainant's heads of argument. But I think it's important to note exactly what we say there, which is what I said to the tribunal yesterday, which is there seem to be only two general explanations. This is with regard to her conduct in Part B in the CIA matters, not the Claim 1 or Part A. There seem to be only two general explanations. Judge Makhubele acted intentionally to further an illicit unknown purpose, or Judge Makhubele acted in a grossly reckless way with utter disregard for the PFMA, the law, and her ethical obligations. So we don't, and I made this very clear yesterday when I addressed the tribunal, there is no evidence before this tribunal of money that was paid to Judge Makhubele, that she acted, or that any purpose has been identified for which she acted. The submission was, we're trying to explain, well, why did she act the way she did? My submission was that it doesn't matter. But I was very clear that there isn't evidence before this tribunal of corruption or anything to that effect. With regard to your question, Judge Mshidi, whether she refused, I think that that is the evidence, as I understood it, of Judge President Mlambo, that at the meeting in mid-January, he and DJP Ledwaba asked Judge Makhubele to assume her, to take the oath so she could assume her duties, and she said she would not do so. So I think it's a fair reading of Judge President Mlambo's evidence to say she refused to take the oath.
Yes, thank you. Well, that's it. Is there anything you just, I'll give you the last word.
Thank you.
Mr.
Yes, I accept entirely my sister's reading of the Act, and I think she's correct. to that extent, yes, then I don't persist with my criticism of her. But as far as the other question is concerned, I did mention paragraph 314, but may I also go to 315 and 316? And I want to read particularly the 316 of their heads of arguments, where they say, whatever her ultimate reasons were, her motive cannot have been for PRASA's interest. Judge Makhubele chose not to explain what her reasons were. She provided false and evasive explanation for why she acted against the interests of PRASA, so as to assist the corrupt. Without a proper explanation, the conclusion is inescapable. Judge Makhubele has no regard to the rule of law. Her interests are self-serving, and that is incompatible with the holding of judicial office. With respect, that those kind of comments are not justified by the evidence.
Is that it, Mr. Masuku?
Yeah, that's it.
Well, thank you. We've heard all the evidence. The tribunal will then adjourn, and we will let the parties know when we don't have to meet again. A ruling will be produced, and copies of the ruling will then be circulated. That is how I understand the process further. Hopefully we would have it when we're all ready and before the next the JSC meeting. We should have it ready by then. Thank you.
You mean we can't do it tomorrow?
No, I can't do it tomorrow. Yeah. Yes, thank you all. We then stand adjourned.